May I please the Lordship? Lordship, with the consent of the other side, I beg to mention item number 36 of today's list.
Yes.
In this case, I'm led by Mr. K. Chaudhary. He has a case in the Supreme Court regarding the car matter. So it may be adjourned for today.
Taken the consent.
Yes. Government side.
That is when do you want?
After
When do you want?
after 2 weeks.
After 2 weeks. On the prayer made on behalf of the petitioner, matter is adjourned to be listed after 2 weeks. Okay, 36. Okay.
May I please, Lordship? May I pay for listing of a petition for day after tomorrow, Lordship?
Motion.
Yes, Lordship.
Bench 5 matter.
Bench side, Lordship. Obliged.
May I please, Lordship, to mention item 45 supplementary list.
Yes.
Lordship, respondent number 4 has filed an affidavit in opposition. So Lordship may allow it to bring it on record kindly.
Please bring.
Obliged, Lordship.
May I please, your Lordship? Lordship, on Friday, Lordship, I filed an IA
For?
for direction from this honorable court to stay and notification. Lord, and the
Stay.
main, Lordship, and the main method is already fixed on tomorrow, but it has not come in the daily list. Perhaps it will come in the supplementary list. So I'm praying, Lordship, may connect it with that matter and may.
Tomorrow the matter is at what stage?
Lordship, in orders, in admission stage, Lordship. Actually, the services has been completed, Lordship.
If it is fixed tomorrow, you can bring the IA.
Yes, Lordship. That's all.
I'd like to mention item number 25, Your Lordship. I'd like to withdraw the matter, Your Lordship. The matter has been resolved, Your Lordship. Item 25, full court.
25.
Okay.
H. Buragohai. 3 H. Buragohai, Learned Council. Are you on record?
I'm on behalf of
Appearing on
BJ
instruction.
Mukherjee, Lordship.
Appear on instruction of Sri B.J. Mukherjee, Learned Counsel for the petitioners, has submitted that the matter has been settled out of court. Full stop. Also heard MS M. Borman, Learned State Council, and Sri S. Datta, Learned Standing Council, Revenue Department. Full stop. Para. Petition accordingly stands dismissed as not pressed.
Obliged.
Yes.
Yeah, please, Lordship. So I beg to mention listing after Bihu, Lordship. It is a matter relating to SBS here. So kindly maybe.
Matter which year?
Matter, Your Lordship, it is the 23 last year. After Bihu, Lordship, any convenient date.
Okay. Yes. Next.
May I please? Well, I beg to mention item number 9 and 24 matter.
9,
And 24.
9 and 24. Yes.
I pay for passport for that, madam. So as per our constitution.
Have you taken the consent?
Yes, madam. From revenue.
9 and 20 on behalf of Mr. Bhattakur.
Yes, madam. 9 and 24.
Okay. On a prayer made on behalf of the petitioner, matter is adjourned to be listed after the Bihu vacation.
Right.
Bilek, huh?
Highly obliged.
Yes.
I think also.
May I please, your Lord? As per petitioner instruction, I have withdrawn that.
Okay. What is your name, madam?
Miss S does.
Miss S. Das, Learned Counsel for the petitioner, submits that there is instruction not to press this application. Full stop. Also heard Miss M. Borman, Learned State Council. Excise Department, who's there? Anybody? Who normally appears for Excise Department? Just inform him. He should come. Ask him to come to the court once later also. And Sri D. Gogol, Understanding Council, Excise Department. What's up, para? Dismiss as not press. Okay. Dismissed on withdrawal.
I think
Interim order. If any.
May I please, Your Lordship? Lordship, this is a contempt petition, Your Lordship. Here, willful and deliberate violation of order dated 18/10/2023, Your Lordship. First in WPC number 1260 of 2021, Your Lordship.
Yes.
And Your Lordship, if will find operative part at page 11, Your Lordship.
Hmm. That's 3 months.
Actress 11.
Part 3 SI Akand, learned counsel for the petitioner who has complained of non-compliance of the order dated 18/10/2023 of this court passed in WPC 3260
1260.
or 1260 of
Of
2021. Full stop. The learned counsel has also referred to the communication dated 5/12/2023
Yes.
issued to the respondent, full stop para. Let notice be issued returnable by 4 weeks. Steps, huh? Within 2 days. By registered postal ID.
Sir,
Yes.
keep clear. Lordship, non-compliance of order dated 21/7/23, my lord.
Page,
Operative part, page 10, my lord, paragraph 8.
ex gratia.
My. 14.8 to the subject.
Okay, same, huh? Order over 21/7/2023 in WPC 7793 of 2022. Or communication dated 14/8/2023. ठीक है, बाकी steps within 2 days.
My lord.
Registered postal ID.
This is also similar, my lord. Page 10 is the operative part.
Ex gratia.
My lord.
এর নাম তো লিখি বাস আগত জেল আস্তর order dated 21/7/2023, same date 7795 of 2022, communication dated 14/8/2023. Your name is not reflected
Oh,
in
my
the
lord.
cause list.
So, my lord,
Registry to reflect the name of Sri J. Lastar in the cause list. Just a minute. Hey, here it is, huh? Local room open, sir. That's it, huh? Here, what do you know?
Apply.
Cause list as counsel for the petition.
Five.
Maybe. Lordship, here, lordship. There is a dispute, lordship, regarding the apportionment of the award money. Lord.
You file your counter affidavit.
Yes, already filed.
Okay.
Yes, sir. Lordship,
When was it filed? 1/4.
yes,
Have you received a copy?
yes, sir.
Okay.
Yes, sir.
Would you like to file any rejoinder?
No, lordship, it can be have.
Then we'll fix for admission hearing. This for motion or will issue notice today? What is the case?
Lordship, here the National Highest Authority, lordship, acquired my land, lordship, and my co-factor. And accordingly, lordship notice was issued to submit necessary documents before it for the award money. And I submitted all the relevant documents,
Hmm.
but till date, no award has been made, lordship. Otherwise, lordship, there is a dispute. Section 3A will come, lordship, it is a matter of civil court to decide the right title of the parties.
My humble prayer, Lord, at this stage, let the Kala refer the matter to the civil court to determine who is the possession of the land, because there is a
Now, how will Kala refer? You have to go to the civil court and raise a dispute.
no, can you see the 3A's of the National Highest Act?
Mr. Boro, you are for whom?
I'm for this one for 3 years. Here the land has not been acquired by us. I am for National Highway Authority.
Who has
Earlier,
acquired? Acquired for whom then?
Was acquired by, I think, PWD and
Is this area actually under acquisition? Madam?
Yes, my lord, some award has already been passed.
Okay.
It is for NH Gauripur bypass, that land has been acquired. As per affidavit mentioned in the affidavit.
our certificate that we have not party land.
No,
It is not for you.
Not
It is for whom? Who is the beneficiary?
Lordship, NFDCL Lordship already started out by
NHA is already stuck off. NHA also is.
No, Lordship, NSA is the
Free.
party.
23 NHA also put it there.
And NSA is the Lordship, there is no dispute, Lord.
Who are the parties? Is it for National Highway Authority of India?
Yes. Yes.
You appear for NHAI?
I RTR Lordship, I appear for NHA DCL also. It was stuck off by order dated 23-24.
Okay, understood. Then,
And then Lordship responded to 2 and 3 NHA Lordship.
hmm,
Here we have received that NHA has not.
you are also not the beneficiary.
No.
Then
No, Lordship, can you please 18 petition, Lord?
you file the affidavit.
Lord, can you for the statement, page 18, Lordship?
No, he is disputing on facts. Let
Yes,
him file
Lordship,
the
I am
affidavit.
referring that, Lord, page 18, Lord.
Let him file the affidavit.
No, Lordship, there is a specific that as per National Highways Act, the land was acquired, but it's on record.
Council is having instructions. Let him put it on record.
Yes, Lordship, I am.
Heard. 3 L.R. Mazumdar.
Is that Ahmed?
You are AZ Ahmed. AZ Ahmed, Learned Council for the petitioner. Full stop. The grievance is with regard to non-receipt of the awarded amount by the petitioner in respect of acquisition of a plot of land measuring 1 bigha, 1 kita, 1 katha, 5 lecha by which according to the petitioner is by the Ministry of Road Transport and Highways. Full stop. The petitioner has also submitted that there is another co-partaner. Full stop. Para. Affidavit in opposition has been filed by the respondent number 5, and in the meantime, comma, the cost title was also amended. Full stop. Para. Sri R. Boro, Learned Counsel, appearing for the National Highway Authority, has however submitted that the acquisition has not been made for his client. Full stop. Para. Be it as it may, let notice be issued, returnable on.
Lordship, no, notice was already issued, Lord.
Which order?
It's Lordship, first order, Lordship.
Order dated
Lordship,
24/1.
yes, Lordship. First order, Lordship. I have not-
24/1 we have seen, notice has not been issued. Returnable on. Returnable on 6th of May, 2024. Who will accept notice? Union of India will be accepting. A? K. Fukan, okay. What is your name, madam? Ms. P. Tamuli, learned counsel, appearing on instruction of Sri K. Fukan, CGC, accepts notice on behalf of respondent number 1.
I'm for two
Sri
and three.
R. Boro, learned counsel, except for respondent numbers 2 and 3,
5 and 6
whereas-
I am agreed.
and Ms. M. Bormon for respondent number 4 and 5.
5 and 6, my,
No, amended cost title,
no, I meant
4 and 5,
4 and
full stop. Let extra copies be served upon the learned counsel for the respondents by tomorrow. Let steps be taken for service of notice upon the respondent number 6 by registered post with AD, steps by tomorrow. The stand of the national higher authorities may be put on record by way of an affidavit.
I move.
May it please the Lord.
Yes.
My lord, 14 writ petitioners were elected uncontested. However, the registrar pursuant to a complaint, although not acceptable in law, decided otherwise. We approached the writ court, and this honorable court at page 106, operative at 111, was inclined to grant the interim order, considering the fact that voter list, good or bad, would not have a bearing on the result because uncontested otherwise. On that point, till returnable date. However, we noticed that the petitioners had filed an application before the honorable minister. Therefore, in all fairness, we wanted to withdraw the writ petition, which showed it with a liberty. We filed the writ petition again, and there we filed an application to withdraw. The registrar did not allow the withdrawal, kept it pending. That's a separate issue, my lord. So we have come back again. If my lord takes up page 111,
Yes.
yes, otherwise,
Lordship may issue notice for that issue.
What has happened to the proceedings there?
proceedings there has been kept in a bed. I mean, he's not allowing us to withdraw. We have shown that we have withdrawn the writ petition. We did not want to take advantage of it. We did not file the additional affidavit. We straight away withdrawn the writ petition and filed the application there. He has kept it pending.
We can do one thing. We can pass a restraint order till the time the matter is settled by him.
No. There,
Two
we have-
parallel proceedings.
my
will not-
lordship, there we have filed an application for withdrawal. He is not allowing us to withdraw on the context.
No, withdrawal because you are contesting here.
No. After we had withdrawn the writ petition, we filed the application stating that since we have withdrawn the writ petition, this is not the correct forum. So the minister and then to the ROCS allow us to withdraw. He's not allowing us to withdraw that. We've even challenged that here. And they allow us to withdraw because in all fairness, whatever happened, we withdrew the interim order. We did not take the benefit of it. What I am praying, my lord, my submissions may be recorded. The order, the documents are there. Herein. The interim order may be passed. Otherwise, the entire thing may go. Re-election may come in. That may be difficult for us. And on this, he may not
Okay.
proceed.
Heard. Sri as Bonik learned counsel for the petitioners. Full stop. The petitioners who are 14 in numbers claim to have been declared elected uncontested in the elections for the, what is the name?
My lordship,
Meherpur
Meherpur, Krishnapur.
Krishnapur Cooperative Society Limited in the district of Kachar. In the meeting held on, it was it 18/3?
Right.
18/3.
Lordship.
18/3, 2023.
Page 82.
Huh?
Page 82.
Yes, 18/3, 2023. Full stop. However, the said election was set aside by the concerned registrar by an order dated 3/4/2023.
21st of September 2023. That's 102.
Not 3/4.
That would come subsequently, 21st of September.
No, 3/4 was the subject matter of challenge in 2052.
That was, my lord is through the discussion. Yes, initial.
3/4/2023, which was the subject matter of challenge in
205.
a writ petition filed by the petitioners being WPC 2052 of 2023. Full stop. This court However, by the order dated 19/7/2023 had intervened with the order dated 3/4/2023 and the matter was remanded to the jurisdictional register for a fresh hearing. Full stop. However, by the subsequent order dated 21/9/2023, the earlier order was upheld. Full stop. The petitioners had accordingly filed the second writ petition 438/2024 assailing the order dated 21/9/2023, in which an interim order was also passed. Full stop. However, since certain vital facts were found to be not incorporated in the writ petition, the writ petition was withdrawn and an application was filed to the respondent number 2 for withdrawal of the appeal oblique petition, which was filed before the concerned minister. Full stop. However, the respondent number 2 has rejected the prayer to withdraw the said application. Full stop. Para. It is the apprehension of the petitioners that since their challenge is presently the challenge which they had instituted before this court was withdrawn on a particular condition, any action taken in the meantime would cause prejudice to them. Full stop. Para. Let notice be issued returnable on 6th of May 2024. Sri S.K. Talukdar, Learned Standing Council, Corporation Department accepts notice on behalf of respondent numbers
1, 2, 3, 4, my lord.
1, 2, 3, and 4. Let extra copies of the writ petition be served upon him by tomorrow. Let steps be taken for service of notice upon the respondent numbers 5 and 6 by registered post with AD. Steps by tomorrow. Heard Sri Bonik on the interim prayer. Full stop. Para. Until the returnable date, let status quo as on today be maintained.
With regard to the election of the writ petition. But the status quo is always with an objective measure. Otherwise, things may go the other way.
You are holding the thing, nothing will be done. Status quo, yes, sir.
All right, Gotcha. And may I take an observation method, subject to correction method, that the jurisdictional authorities may not proceed further with the matter. Jurisdictional authorities may not proceed further with the matter.
Let us go, will take care.
Status quo.
That's going to take. But
Item 7. Maybe the lordship. Lordship, in this petition, I am challenging the order dated demand come show cause notice dated 14/2/24 issued by the respondent number 2 on page 190, lordship.
190.
Lordship. Lordship, this show cause is containing that certain interest which were given to us.
Yes,
by the
yes, amalgamated.
Lordship.
Issue has been settled, I think.
No, that is settled, Lordship. What happened due to protective demand, they have issued this notice. So I talked to the authority, the concerned officer is on leave. But may take up, probably we will withdraw that notice. On
I
last
think
occasion,
it's
Lordship,
settled, I think.
they have been protected by
It's a covered law,
on
lordship.
last occasion.
Okay, okay. Let us issue notice. You may withdraw in
Yes.
the meantime.
Okay.
Yes, what is your name?
That's it, lordship.
Whose name we record? S. Mitra, two S. Mitras.
My son.
That is it. Whose name should we record? S. Mitra, do in bracket son or father? Heard Sri S. Mitra, Learned Counsel for the petitioner. Full stop. The challenge in this petition is with regard to our demand come show cause notice issued, dated 14/2/2024, issued by the respondents. Full stop. It is submitted that the subject matter of the impugned show cause notice is already settled by the Honorable Supreme Court in the case of Union of India versus Amalgamated Plantations within bracket private bracket close limited in WPC 1166 of 2012 and 2325 of 2012, which was decided on 8/11/2012. Full stop para. Let notice be issued returnable by 8th of May 2024. 3 S.C. Carl, learned senior standing special counsel, senior standing counsel, CGST accepts notice on behalf of all the respondents. Full stop para. Let extra copies of the writ petition be served upon him by tomorrow. Full stop para. 3 Kyle, by the learned counsel, by referring to the earlier order dated 1/4/2024, has in fact submitted that the matter is being reconsidered. Full stop. On the next date, comma, let the outcome of such reconsideration be informed to this court.
The interim order passed earlier might be.
The interim order passed on 1/4/2024 would operate.
Obliged,
Would continue till the next date of listing.
The petitioner along with some ONGC employee purchased some land at Petkuchilote by separate registered deed. So thereafter, the petitioner name has been recorded in the revenue record as per settlement operation. And Patta name has been entered. Thereafter, one of the legal heir of when Dekamaji, he has applied to the ADC saying that no notice has been served to him for recording their name in the revenue record.
Who is he?
He is the son of Upen Dekamaji.
Who is Pandeka?
Upen Dekamaji, 3 brothers who are the joint owner of a plot of land.
Your vendor.
Our vendor.
Okay.
His son filed an application to the ADC that no notice has been served for recording the name in the revenue record. Thereafter, the ADC has directed to cancel the mutation order. Thereafter, petitioner has approached the Board of Revenue. Board of Revenue also affirmed the order of the ADC by common order. Against that order, 4 writ petition has been filed, and this petition has been allowed by the Honorable Court, directing to restore the name of the petitioner. And accordingly, restoration has been done. This petitioner has been left out. He has also filed an application before the Honorable Court. Honorable Court directed that as per order of the Honorable Court, that the demand passed in common judgment, that is set aside. So his name should be recorded. Common benefit, not recorded. Common benefit should be given. That order was not implemented only on the ground that in the earlier order, Lordship will find the earlier order of this Honorable Court, page Lordship will 61.
6-1.
Page 61.
Yes.
Relevant portion Lordship will find 86, 83.
Yes.
Page para 41 Lordship. Having found common judgment and order that the demand passed by the learned revenue board, that the demand passed by additional deputy commissioner wherein the revenue appeals had arisen unsustainable in law for the reasons mentioned herein above, writ petition by setting aside those orders impugned herein are allowed. Interim order if it is then merged with this order as a corollary mutation of respondent respective plot 1, 2, 3,
Yes.
and 4. That is why Lordship petitioner name has been not corrected by the authority. And this Honorable Court directed by order dated page 86.
You were not one of the litigants in this route. You came later.
Came later.
Where is your order?
Page 86 is the relevant portion.
86.
Page 85 onward, 86 relevant portion. It appears that no notice was earlier issued to the private respondent.
Yes. Now, where is the order? What is on any order passed?
No, nothing has been passed. We have filed representation one after another. Nothing has been passed.
Yes, madam.
Already, Lordship, other person has been
What
recorded.
instructions in this type of matters?
Because not the litigant in earlier proceeding.
So he has filed a
That-
second.
That might be his name. may
So
not
he
be
has filed a
recorded.
second petition. And if you don't understand the meaning of the second order at page 86, then matters Does not seem to be in the right perspective. See page 86, the last paragraph. It appears that no notice was earlier issued to the so-and-so petition stands disposed of in terms of the order dated. What more do you require?
In time.
Whom did you approach?
Lordship, I have approached, Lordship, circle officer, dispute revenue circle.
That petition is pending.
Circle officer
Page
doesn't know
103.
what to do.
103.
Why this kind of harassment, madam? Why should you come to the court again?
And other petition, they have also filed affidavit, private respondent also filed affidavit to that effect. They have no objection or recording to them. Due to misunderstanding, they have. filed
No,
affidavit.
those matters we are not even entering. There is an order of this court which has attained finality. He was similarly placed. He came late with another petition. Court gave him the same benefit. Now you are saying that his name is not there. So what is this kind of understanding? Who is the circle officer?
Lordship, he has been arrested and he has been now removed. Now new circle officer.
After his bail, he'll come to this court. First we'll grant him bail, then he'll call him to the court.
So he had said. Government said.
This is not fair, madam. Why unnecessary litigations? Why do you increase the burden of the court with this kind of matters? Is it a matter for any raising a dispute at all?
Others' name has already been recorded. Page 98, as per order of the court.
Third, Sri S.K. Goswami Learned Counsel for the petitioner. Also heard Miss, who are the respondents? Yes, Miss G. Hazarika, Learned Standing Counsel Revenue Department. And Miss M. Borman, Learned State Counsel. But there are two private respondents.
Private respondent, they have already filed affidavit to that effect. They have no objection in the early repetition. Lord, you will find their affidavit early repetition, page 51.
Mr. Goswami, it will not be fair to dispose if we'll say something else. We'll issue notice, but we'll pass some orders. The case projected is that the petitioner had purchased a plot of land measuring 2 katha wide, a registered sale deed dated 10/7/1996. Please have your seat. Full stop. Accordingly, the name of the petitioner was mutated and patta number 5 mutated and his name was entered in the concerned patta number 5. Full stop. However, comma, on the application by an incumbent claiming to be the legal heir of one of the vendors, comma, the mutation was cancelled without any notice, and the said decision was also upheld by the learned Assam Board of Revenue, within bracket ABR, full stop. The aforesaid order dated 4/8/2014 of the learned ABR was the subject matter of challenge in 4 numbers of writ petitions filed by the persons who were similarly placed with the petitioner and had purchased
Of the same vendor.
from the same vendor. Full stop. The said writ petitions were allowed and the impugned decision of the learned ABR was set aside, and accordingly the revenue record was corrected. Full stop. Para. Since the petitioner No, subsequently, the petitioner had also filed WPC 3467 of 2022. And this court, wide order dated 5/8/2022, had directed the respondents to give the same benefits. Full stop. Para. It is the case of the petitioner that in spite of communication of the aforesaid order dated 5/8/2022, no action has been taken till now. Full stop. It is submitted by Sri Goswami that the reason which could be learnt by the petitioner is that since the order did not specifically mention the name of the petitioner, the fruits of the litigation has not been given to him. Full stop. Para. Let notice of motion be issued returnable on 8th of May 2024. Ms. Hazarika, the learned Standing Council Revenue accepts notice on behalf of respondent number
One.
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 And Ms. M. Borman, London State Council for 2, 3, and 4 extra copies within 2 days. 5 and 6 by registered post with AD, 2 days. Para. Goswami, the learned counsel prays for an interim order. Full stop. Para. Considering the facts and circumstances of the case, it is directed that pendency of this case shall not be a bar for the authorities to consider and implement the order of this court dated 5/8/2022, as the same has clearly mentioned that the said order is passed in the line of the earlier order dated
17/2/2020.
17/2/2022, 22, passed in the 4 numbers of writ petitions filed by similarly situated petitioners
Against the same order.
against the same order,
Apply.
against the same order of the learned ABR.
Apply.
Item 10.
Sir, the petition has been filed, the non-action on the part of the respondent authority to dispose of the petitioner's application under sections 107 of CRPC, which is still pending before the respondent number 3.
When did you file 107?
On 21st December 2023,
Yes, madam, instruct.
Section is 75.
We issue notice heard Sri H. Barua, learned counsel for the petitioner. Full stop. In connection with a transaction for a plot of land which the petitioner claims, plot of land, transaction of 2 plots of land which the petitioner claims to have purchased by registered sale deeds, an application under section 107 CRPC has been filed on 21/12/2023. CRPC. The commissioner, he exercised the power of executive magistrate.
In view of notification,
He is given the powers of executive magistrate.
Lordship,
Madam?
107,
Okay.
there is a notification has
There is a
been,
notification
Okay,
with respect to-
okay. কি করলো last time? before the Commissioner of Police, Kamrup, within bracket Metro. Full stop. On 21/12/2023, comma, though the said application was forwarded to the Deputy Commissioner Police within bracket crime, comma, no further action has been taken. Full stop. Sri Barua, the learned counsel for the petitioner has clarified that by the notification, comma, the powers conferred by section 107 CRPC before to an executive magistrate has also been delegated to the Commissioner of Police. Full stop, para. That notice be issued. Returnable. Returnable. We can dispose this off. Do you have instructions?
No, my
Okay, we'll issue a short notice. There may be something else. Let notice be issued returnable on, we'll have it on 3rd of May. Okay, 3rd of May, 2024. Ms. M. Borman, London State Council accepts notice
Okay.
on behalf of all the respondents. Extra copies within 2 days. Para. Pendency shall not be a bar for proceeding with the application under section 107 CRPC said to be filed by the petitioner in accordance with law. Yes. Yes.
My lord, in this case, whatever, my lord, there is a so-called notice issued by the Deputy Commissioner of State DST, my lord. Then, my lord, will find it in Annexure 1, my lord. Then, as against the supposed notice, my lord, the reply was filed by Annexure 2, page 21, my lord. And, my lord, as per requirement of the, my lord, the GST, my lord, it is to be uploaded in the system, my lord, which will find it Annexure 3, page 23, my lord. But once it is uploaded, my lord, then this a number is allotted, my lord. That is ARN. That is what Lord will find at the left side, my lord.
Yes.
But what happened, my lord? Then after the safety to the even this supposed reply, my lord. What the GST Deputy Commissioner has done, my lord, Annexure 4, my lord, the order was passed under section 73. My lord,
29/12.
yes, my lord. Holding that, my lord, there is no response from the my lord, petitioner. So, my lord, it is apparently mistake and by them, my lord. And
Yes, yes, Mr. Gogol.
I'd like to have the short instruction on this.
And my lord, already,
Don't take any coercive action. Okay.
my lord,
Because he's on a different footing altogether.
a
On
similar,
merits, if you dismiss, that's a different matter.
a similar matter has already been, my lord, already moved by this.
Now we are granting some interim order to you. Let him take instructions. Heard, Dr. Todi, the London Senior Counsel for the petitioner. Full stops. Para. The Deputy Commissioner Sales Tax, comma, Borpeta Road 1. Why Borpeta Road 1 and Guwahati Zone B are same?
Well, this is not known, my lord. In fact, Deputy Barpeta Road,
Sales tax, comma, don't write Borpeta Road, comma, Guwahati Zone B had issued a show cause notice. Full stop. The petitioner claims to have submitted the reply online on 20/12/2023, for which an acknowledgement number ARN, it is syllable, huh? ARNZ, by the most number it is. Synopsis it is. Was issued. Full stop. However, comma, on 29/12/2023, the impugned order has been passed confirming the levy of taxes on the ground levy of taxes, and it was observed that the petitioner had failed to respond to the so-called notice. Full stop. The said order was, the another order of the same date was passed for attachment. Full stop, para. 3. Dr. Todi, the learned senior counsel, has submitted that the acknowledgement number itself would prima facie show that the show cause reply was actually filed, which has been ignored. Full stop, para. That notice be issued, returnable on 3rd of May, 2024. 3. B. Gogoi learned Standing Counsel, Finance Taxation Department accepts notice on behalf of all the respondents.
All.
Extra copies 2 days. Full stop, para. A prayer for interim order has been made. Full stop, para. Considering the facts and circumstances, comma, it is directed that no coercive action of any manner be taken pursuant to the impugned orders dated 29/12/2023 till the returnable date.
My lord, Lord, may kindly, my lord, observe that and the GST DRC page 26, my lord, that is two orders has been.
Two orders, we have said 2 orders.
Yes, my lord.
Both same date.
Then DRC 07, same date, my lord.
Same date. Orders question is.
Much obliged, my lord. My lord, in this case, my lord, the petitioner is a
Yes.
the petitioner filed a return of the Income Tax Act, my lord.
Hmm.
And my lord, which will also will find it, find my lord that annexure 1, my lord. And
Yes.
thereafter, what happened, my lord, as per requirement, as per my lord, provision of section 119, the Income Tax Act, my lord, there is a provision, my lord, that one can file, my lord,
Revised.
revised return, my lord.
Yes.
So, my lord, in fact, my lord, page 35, annexure 2, that my lord, the condition of delay, my lord, was application was filed
Yes.
for my lord, for submission revised return, my lord.
Hmm.
Another was reminder was sent, my lord, that was again, those will find the annexure 3, my lord.
Hmm.
Finally, my lord, when my lord, nothing came out.
Yes,
my-
yes, Mr.
Lordship, may please to see page 41.
21,
41,
41.
close date.
Clause 8.
It is there, my lord, left side,
Yes,
the closed.
Please specify the
8-6.
reason for not filing the return within time.
yes.
The reply is, I became aware of the introduction of section 4480A in 2020 only and wanted to file the revised return for the year 17-18. But the last date of filing revised return was over by then.
This is of 2020. Will it have retrospective
Yes.
effect?
My lord, may I
Lordship,
submit?
please to see
No,
the
notification of 2020, introduction of 44ADA. Will it have a retrospective effect for the returns of 17-18 and 18-19?
My lord, it's not that, my lord. In fact, my lord, let me submit, my lord. In fact, what happened? My lord, as per, my lord, what happened? My lord, after
Okay,
the
we'll issue notice of motion.
Yes.
Let us examine.
yes, sir.
But that is an issue we'll have to address.
Yes.
Heard Dr. Todi, the learned senior counsel for the petitioner. Full stop. The grievance is non-consideration of an application by which a request was made for filing revised returns
my lord,
as envisaged under section 1,
my lord,
section
section 119,
119,
subsection 2, clause B,
within bracket 2, within bracket B of
Small.
the Income Tax Act
1961.
1961, full stop. It is submitted that since the statute itself provides for filing an application, comma, consideration of such an application is a mandatory requirement, full stop, para. Let notice be issued, returnable on 8th of May 2024. 3. SCL, learned Senior Standing Counsel, CGST.
Income tax.
Oh, this is Income Tax Department. Accept notice on behalf of all the respondents. para, let extra copies, huh, within 2 days. Full stop. Three. Kyle, the learned counsel for the respondent, however, submits that admittedly the revised application has been filed to claim benefits under section 44 ADA, which was introduced in the for the assessment years 2017-18 and 2018-19 in the ITR 4. Full stop. However, the said introduction was done in the year 2020, and therefore the question of and therefore it prima facie appears that such benefit would not be applicable to the petitioner, and therefore and consequently there cannot be any fault in rejection of the application. Full stop. Para. The aforesaid contentions would be considered at the appropriate time. Full stop. Para. Let affidavit be filed in this regard by the respondents.
Extra copy.
Extra copies, yes, we have already noted.
Yes, sir.
Mr. Nath, give extra copies.
Item 13.
Yes.
This is a matter pertaining to the non-registration of FIR Lordship by the Doboka police station on several approaches. Your Lordship, on the first approach, when the FIR was not being registered, he approached the Superintendent of Police, Gujai, and he.
You had approached the SP?
Yes.
Also?
Yes, and he has accepted the same and has made a reference 6063 and has been forwarded to the Doboka police station. In the meantime, Doboka police station on the several locations on the approach of the petitioner, they state that they have lost their records. The officer in charge was not the officer during that period of time, and they have refused to give any information. And in this regard, RTA application was also made, and he was also not being given any reply to it. And again on 7/2/2024, recently, Lordship, since the approach of the accused person has increased, another affair was being lost, and same was directly being refused.
Yes, madam, normally this kind of matters we do not interfere, but
In terms of circuit.
he is making consistent efforts to get his thing registered and
Let me have
investigated.
the status.
You
registered
get the information. S. Ahmed,
Yes, ma'am.
Heard 3 S. Ahmed Learned Counsel for the petitioner who is aggrieved by inaction of the police authorities either to register his FIR or to investigate in the allegations made. Full stop. It is the case of the petitioner that his initial FIR was refused to be registered as for which, he had approached the Superintendent of Police, Hojai, by an application dated 10/8/2022. Full stop. It is claimed that the aforesaid application was duly forwarded to the concerned PS, even after which no FIR was registered. And in the meantime, the misdeeds against the petitioner had continued by the same miscreants who are named. Full stop. Para. Though non-registration / inaction in investigation may not be entertained by a writ court, the allegations made in this petition may require a slight departure. Full stop. Para. Would require. Let notice be issued, returnable on for record. Full stop. Not don't say record. Be that as it may, let instructions be obtained by by Miss M. Borman, the Learned State Counsel, on the status of the
Pending.
Azahars
Pending
said to be filed by the petitioner, including the endorsement by the Superintendent of Police Hojai allegedly made on 10/8/2022. Full stop. Depending on the instructions, comma, appropriate orders will be passed on the next date. That's all.
Fixing any.
We had said which date? Acha, list on, we're having on 3rd of May.
Right.
All right. Para, to facilitate the London State Council to obtain the instructions, comma, let an extra copy of the writ petition be served upon her during the course of the day.
Apply.
14.
That is okay. The petitioner is a particular landholder, my lords, of land measuring 2 bighas of village Dokhin Gaon is to press for investigation and for demarcation. And file these 3 numbers of representation before the circle officer as well as district commissioner, but not considered.
Demarcation, Public
Yes, sir.
Services Act,
Lordship, it is a notified service.
notified service.
He may file an appeal before the ATC, your lordship, within after 30 days. If the circle officer is
Have you
not
filed the
providing
application?
service,
You have filed.
Already filed, my lord, to an extent of 5, not appeal,
appeal he has not preferred, your.
only request.
Heard, Sri B. Islam, Learned Counsel for the petitioner. Also heard. Miss. Madam, you're for,
I'm for respond number 1 and.
and what law for one,
Yes.
and,
I'm for respondent 20.
oh, there are private respondents.
Many private respondents. sir.
We would have disposed this of. Without private respondents. Okay, we'll do one thing. We'll ask them to be given a notice. Okay. J. Hendrick, Learned Counsel, State Council. Full stop. In view, in taking into consideration the subject matter and in view of the order proposed to be passed, comma, notice on the private respondents may not be required at this stage. Full stop, para. The facts projected in this petition is that the petitioner and his mother are patadas of a plot of land measuring 2 bighas in revenue village, Dakhin Gaon, dekh lijiye, under Dispur Revenue Circle, comma, Kamrup within bracket M. Full stop. The petitioner claims to have filed a representation dated 8/1/2024 before the circle officer, comma, Dispur Revenue Circle and the district commissioner, Kamrup M, for demarcation of the land in question covered by Miadi Patta numbers 8, 9, 10, 11, 12, and 31. Not 13.
31, man.
31. And dark numbers 226, 231, 232, 234, 235, 236, 237, and 627, which however has not been considered. Full stop. The Learned Counsel accordingly prays for a direction for such consideration. Full stop. Para, Ms. Bodloy, the Learned Standing Council Revenue, as well as Sri Hendrick, the Learned State Council, however, submits that the issue involved it can be redressed by taking into consideration the Assam Right to Public Services Act 2012, under which, comma, demarcation of land is one of the concerned services, full stop. It is also informed that in this regard, an office memorandum
Yes.
dated 21/12/2020 has also been issued by the Revenue Department, which lays down even the procedural steps for issuance of demarcation certificate, full stop para. In view of the aforesaid facts and circumstances and the submissions advanced, comma, this court is of the opinion that interest of justice would be served if the petitioner is directed to file a proper application by following the procedural steps laid down in the OM dated 2020, which has been issued pursuant to the Assam Right to Public Services Act 2012. Full stop. The petitioner is accordingly directed to file such an application within a period of 15 days from today. Full stop. It is needless to state that since the present writ petition has been disposed of at the motion stage, wherein private respondents, in which private respondents are also there, comma, before passing any orders, comma, the said respondents who are parties in this petition are to be given notice, full stop, to enable notices to be issued to the concerned respondents, comma, the petitioner is required to indicate the names and addresses of the said respondents in the application, which he may file within the period stipulated above, comma, full stop. The application, if filed, is to be disposed of within the time prescribed after issuing notice to all the stakeholders. Yeah, after issuing notice to all the stakeholders and giving an opportunity of hearing.
May I please say, Lordship? In this case, we have challenged the Lordship impugned order in original, which your Lordship will find at page 316. Lordship, this order consists of two parts, Lordship. One part we have admitted and we have paid the entire tax in respect of that part. There is interest which has been levied, Lordship, of two amounts. One is 10 lakh rupees for inadmissible ITC. And second, Lordship, which your Lordship will find at page 319, has been levied on the dictation of some other officer. Lordship, may kindly see page 219.2.7.
Page
319. 2.7. Lordship, before that, the first part has been discussed. That is levy of 10 lakh rupees. Thereafter, from 2.7, the levy of the second part arises. Page 319.2.7.
Yes.
Lordship, point 2.7 says, whereas subsequently a letter was received from Superintendent of Anti-Evasion Unit regarding recovery of interest on net case liability with effect from 1/7/2000 under the provisions of section 50 of the White section so and so, and as notified by CBIC with effect from 1st day of September by notification number so and so. As per communication received by the from the Superintendent Anti-Evasion, the said taxpayer is liable to pay interest of rupees so and so on delayed payment of tax from the so and so. Lordship, this order has been passed only on the dictation of this officer, Lordship, and therefore it is bad in law. Lordship, the Lordship may kindly see the amount is 6 crore 37 lakhs. Lordship, finally, the levy is made. Lordship may find at page 325. 325, the final amount comes to Lordship. This is 637. The final amounts, Lordship, is I confirm the demand of interest amounting to 647. So
Yes.
it consists of both the amount, 637 and 10 lakhs. Lordship, this 10 lakhs I have paid because I have admitted that amount. And Lordship, I have annexed my challan at page 327 of payment of Lordship 10 lakhs rupees. Lordship, I'm challenging only this part of the order which has been passed at the behest of some other officer. And since it has been passed on the behest of some other officer, it is null and void, Lordship. Anyhow, also, Lordship, interest is not leviable in this case, Lordship. Because Lordship, as per the judgment of the Madras High Court, that is on merits, Lordship, I am submitting. Madras High Court, Lordship, if an amount which is refundable to me is lying with the department and there is an amount payable to me. So, Lordship, the amount payable is much less than the amount which is receivable by me. Lordship, then in that event, Lordship, interest will not be payable because the same department is holding my amount. So, and they are not giving me interest. So that can be adjusted, Lordship. There is a judgment by the Madras.
Which is the amount of yours which is being held by the department?
Lordship, the amount was held by the department. Lordship, may kindly see.
How much is the amount? Why was it held?
18.81 crore.
Why
Lordship,
was it held?
Lordship, page 261. Lordship, there is an order passed by the authority whereby it has been, Lordship, it has been indicated that 18.81 crore is what is refundable to me. My payable amount was 5.37 crores. So, Lordship, they got delayed in giving me that refund amount. So, Lordship, that could have got adjusted, and Lordship, there was no interest which is payable at least by me, Lordship. I have
Okay,
paid the
Mr.
entire amount of
Gogoi-
tax.
Dr. Gogoi, what do you say?
Lordship, the amount which has been paid, it is under the scheme, one budgetary support scheme,
The 10 lakhs.
that time.
No, what about this second number, 6 crore 37 lakhs?
This notification, Your Lordship, we have mentioned about, if Lordship permit me to go to 321,
Yes, 321, please.
pay paragraph 6.
Yes.
What is the amount, Your Lordship? Personally, here the case was 6 and 8 September 2000, Mukesh Thakur and authorized representative of the state assessee appeared before the understand for the personal hearing. Regarding the demand of British has he retained amount of his letter details to answer it depends against the proportion. Thereafter, Your Lordship, if you go, Lordship, to the last part, in spite of the blockage funds, the government may have manage funds for payment of GS liability and also partly paid the same to be exchequer in India's GST electronic cash credit, page 32, Your Lordship. On routine basis, same should be considered and finally interest were levied. 18% should not be charged. Onion charged for ad hoc payment were actually deposited to the government before actually filing of GST return. So this is a ad hoc payment they have paid, not in full. On the basis of partly payment they have paid, and on the basis of that.
Madam, 2.7 is just a narration of the letter from the Superintendent of Anti-Evasion Unit.
Yes, Your Lordship.
It is not a direction for you to pay 637. The direction comes, which has been rightly pointed out by Dr. Gogoi after at page paragraph 6 at 321. A hearing was done. It is not on the
But
basis.
the hearing was done. I
And
admit
if
that.
it's,
But
if it is
but-
done after hearing you, prima facie, where is the case?
no, Lordship, I am just only submitting that on the, even the SOCO's notice was issued on the dictation of the mother officer. And Lordship, on the
No,
dictation
that
of the
can be
mother
done.
officer.
Somebody may
Lordship,
detect, but it is not that some officer has said something.
Hmm.
So by closing our eyes, we just make a demand.
Lordship,
They had given you a hearing, you got the
Lordship,
opportunity.
Lordship, I submitted, the opportunity of hearing was no doubt given to us and I have submitted my reply. But Lordship, the final.
But where do you
Lordship,
make
the
out a
consideration-
where do you make out a prima facie case?
Lordship, the demand of 6 crore 37 lakhs, Lordship, as per the Madras High Court, Lordship, may kindly see the order of the Madras High Court.
Have you ordered pleadings that your amount was lying with them?
Yes, Lordship.
Where
that
is the
my-
pleading?
Lordship, the pleading is this is my exact case, Lordship.
Where is the pleading?
Lordship, may kindly see from the head, Lordship synopsis also, as well as Lordship, I'll take it. Lordship, may kindly see the page 3 of my synopsis.
No, pleadings.
Pleading, Lordship. Lordship, page, paragraph 40,
Page
Lordship 107. 40 and 41, Lordship, I have made a specific.
107.
Lordship, may kindly see from the 5th line from the above, page 40, the rationale behind.
Paragraph 40,
Yes, your lord.
where?
That the petitioner, 107 page paragraph 40, that the petitioner most respectfully beg to submit that the proviso to section 50 waives the liability to pay interest on delayed payment of self-assessed tax by an SSC before initiation of recovery proceeding only to the extent the same is paid through electronic ledger. The rationale behind such waiver is that tax paid using ECRL was
No,
all
no, we
along
are not, we are not, on-
available to the
we
revenue
are not,
authority.
we are not on that. We are on the facts. Come to 108. The petitioner, this is a very vague statement. The petitioner in its credit
From the
from the
department.
department had sufficient balance. How much?
Lordship, it was 18.80 crores.
Where have you stated?
Lordship, the order is there, Lordship, at page, Lordship, it is, the Lordship statement is also there, and Lordship, paragraph 41 is, Lordship, also, it has been stated that no laws have been caused to the DST department or to the government exchequer by the
This
petitioner.
will only,
And the balance lies with the department, same
Madam,
government.
this will only be on the context of the interest part.
Yes, your Lordship.
What about the main,
Tax amount I have paid for,
10 you have paid only,
and entire amount I have paid.
6, the other one?
The entire amount I have paid the tax amount, it's only the question of interest.
No, you have just submitted that you had paid 10 lakhs. The other part is the subject matter of challenge.
Lordship, that other
You
part
have
is the
paid.
interest. That is the interest part. only.
Which part?
Lordship,
Interest
the
6
orders.
crore.
Lordship, the 6 crore is interest, Lordship, they have levied. Without even, Lordship, calculating. The amount has not been calculated. It has been on the behest of the superintendent that he has levied. He has not even calculated. 6 crore 37 lakhs is interest, Lordship. Tax I have paid in full before the passing of this order. Lordship, may kindly see 325, the order is there. I confirm demand of interest. It is only interest. I have paid the entire tax. Entire tax has been paid
How
by
much
me.
is, how much amount is you are on credit from the department?
18.80 crore.
Where have you stated?
Lordship, it is there at page, Lordship, may kindly see at page 261.
261.
Yes, your Lordship.
261.
Yes, your Lordship. This is an order, Lordship, it starts from 260. This is the order by the Lordship, the department officer. Lordship. Have you, Lordship, got it? Page 261, Lordship.
Yes.
Lordship, point 1. As on date, they have GST dues of only 5.37 crores for the months of November and December 2020. Accumulate budgetary receivable is now 18.81 crore. I had liability to pay 5.37 crores, but my receivable amount was 18.81 crores lying with the department. Okay. Due to the non-receipt of amount of BSS, they are facing immense financial pressure on working
Now,
capital.
this is your contention, madam. The taxpayer wide letter, this is your contention.
Lordship, yes, your
Where is
Lordship.
the
And
finding?
this is the Lordship. This has been accepted by them in this order.
Where?
Lordship, discussion and finding. Before making any discussion regarding the present case, it would be appropriate for me to discuss the arrangement of reimbursement notified by DPIT by notification. Under the notification, funds are authorized by DPIT to DTOs. Thereafter, the division disperse the funds to the eligible.
Here, this is the last line. I keep the question of entitlement to receive budgetary support open.
Open. Thereafter, Lordship, he has passed the orders.
Where?
Lordship, next page, 263. Pass the orders. Lordship, this is a series of orders. They have reimbursed me the amount.
Where?
Page 263, Lordship. It starts from 263. Next page 264. I hereby sanction an amount of 2 crore 32 lakhs. So and so. Thereafter, again, one order is there. The total amounts to come to 18 crores, Lordship. Page.
This has been paid to you or not?
No, that has been paid, and I have paid the entire amount of tax also. This amount is
This has been paid to you. How do you equate the interest which might have been levied on this amount? Amount has already been paid to you.
The amount has been paid, Lordship.
Well, examine.
Yes, your Lordship.
Best.
Yes, your Lordship.
Isn't there any provision for appeal?
Yes.
Huh?
Lordship, but Lordship, against this order, Lordship, the tribunal has not yet been.
There is a provision for appeal.
Is it available?
CRPC isn't there.
No. Is the forum available?
Well, but if Lordship permitted to go to the appropriate forum, that will be.
No. Is the forum available now? Madam has said that the forum is not there. It's not constituted.
I mean, to take it.
Okay. Heard. Miss N. Havelia, learned counsel for the petitioner. Full stop. The petitioner, which is a company, has put to challenge an order in original dated 27/9/2023 passed by the Assistant Commissioner, CGST. And what is CX?
Central excise.
Right, is Central Excise and
Yes, sir.
Central Excise, Silchar Division, by which a demand of rupees 6,47, 15, 943 bracket as interest has been made under section 50,
73.
under section 50
50 is the
50.
interest.
Penalty.
of the CGST Act 2017. Full stop. It is the contention of the petitioner that the reply has not been considered in its proper perspective. Full stop. Para. It has been submitted that in spite of financial constraint, an amount of rupees 10,08,488 has been paid by the petitioner on 31/10/2023. Full stop. Para. The primary contention of the petitioner is that there were receivables from the department which otherwise would have accrued interest, and without adjusting such interest, the impugned order has been issued, which has been termed to have been done in a mechanical manner and without any application of mind. Full stop. Reliance in this regard has also been placed on a judgment dated 6/1/2020 of the Honorable Madras High Court in WPC, in which it has been held that before making any such demand on interest, an exercise is required to be done on the aforesaid aspect of adjustment, if any. Full stop. Para. That para 3 under Dr. Gogoi, the learned CGC, however, submits that the order impugned does not suffer from any legal or factual infirmity, and in any case, there is an appellate forum in which the petitioner can espouse their grievance, and therefore this writ petition is not maintainable. Full stop. Para. Let notice be issued, returnable on 1st of May 2024. Dr. Gogoi, the learned CVC, accepts notice on behalf of all the respondents that extra copies of the writ petition be served upon him by tomorrow. Full stop. Para. The aspect of maintainability of this writ petition is, however, kept open.
But if there may not be any coercive action.
Will not direct it. The prayer for interim order would be considered on receipt of instructions by the learned CGC.
On what?
16.
Where is your lord? Caveat is there, my lord.
I am protected. Check your.
That's not about 12.
Who has filed the caveat?
That's not about 12, my lord. 12.
Heard Sri B.P. Bora, Learned Counsel for the caveat who has lost this caveat in respect of an order dated order dated 19/2/2024 issued by the District Commissioner, Morigaon, in connection with establishment of a brick kiln, full stop para. The caveat would be heard in the event this court proposes to pass any interim order. Caveat stands discharged. Yes, Mr. Bora.
District was going on since 2012, my lord. We have 7 rounds of litigation.
Seventh.
7 rounds of litigation, my lord. Earlier, my lord, 2 litigation and re-appeal by me and my lord.
7 round is not bad for you, I think.
The same issue, my lord. So problem is started.
It is not bad for you,
So, yeah, very good. Otherwise,
especially Bihu time.
yes.
But it is not good for the system. If one petitioner has to come to the court for 7 occasions,
7 occasions, my lord. The problem was because
then how do you take care of the pendency factor?
because matter you refer to the TC, my lord, and they passed a lot of one part.
Now, what is your grievance now?
Grievance is, my lord, lordship kindly see the order, that impugn order, that is page 19, page 170, my lord. And extra 19,
You were 10 petitioners.
my lord.
10 petitioners.
10 petitioner, my lord. Well,
Yes.
all the they are a cultivator, my lord. If
Cultivator.
they are adjustment, my lord, that quickly is going to be established, my lord. But before going to my lord,
Where is pollution control? Yes.
before going to that order, my lord, that lordship kindly turn to the division bench, single bench order, my lord. Kindly see the, my lord, page 167, my lord.
Mr. Bora is the owner of the brick lane. So you're happy.
This is
Concept of what issued by
No, you're happy or unhappy? Happy. Yes.
before going to that order, my lord.
You're
lordship-
making them unhappy with your brick clean. Where are you having your brick clean in their area? They want to live peacefully with fresh air,
No,
unpolluted air.
As already stated, there are 7 rounds of litigation. There are committees constituted by the Honorable High Court who have inspected and found that it is not an agricultural lane.
Okay. Committee constituted by the High Court.
Yes.
No.
And secondly, there are what is most surprising is there are 4 other big claims.
They are not against those.
They are not against, which are closer to Pavitra. Now they are only against me. So basically, this is read of a commercial interest. They are
Mr.
just-
Barua, are you the owners of the other brick lane?
No, my lord. Well,
You're not the
And
owners.
they are parties.
wrong statement they have made, my lord. They
They
are
are-
making a statement. since
No,
2012.
Owners are your relatives. Friends.
I'm Purva there, my lord.
No, owners are relatives.
I mean, I don't know. But I have seen there is no brick.
Not
my lord.
Mr. Barua's relative, relative of the 10 numbers of
very-
petitioners.
I don't know. The wrong statement, my lord. Because I
Okay, we'll come to you. Let us hear him.
before going to my lord, that impugn order, lordship kindly come to my lord, page 167. That is a direction passed by this honorable court. Kindly turn to page 167.
167.
167, paragraph 12. That is a direction, my lord. Kindly see. Internal paragraph 12, my lord. Has your lordship got it?
167.
The last petition is the direction, my lord. The last petition.
What is the price of 1 unit of a brick? Do you know? You do not know. Have you asked your client? What is the price of 1 brick, 1 piece of brick? Any idea?
Well, I think in Jorhat, my lord, I found that.
Why Jorhat? Where do you go to your
No,
Jorhat?
17, my lord. But yeah, that I know, my lord. Your last month I went there.
You forget Jorhat. Huh? It's 15 or 16 rupees in the retail market.
Jorhat, my lord, 17.
It's a very thriving business.
But I have asked, it is 11 rupees now.
It is in your brick lane, not in Guwahati.
How you can that?
Yes, this is the order 19-2.
Yes, my lord.
What
That
is
my
this
lord.
order?
There is, my lord, paragraph 12, my lord. The order dated 2/3/2019 passed by Deputy Commissioner Morigaon, by which the no written certificate issued the petitioner dated.
Where are you reading? 169?
No, 167, my lord.
167?
That is the last order of this honorable court. That's the direction.
Okay, just a minute, please. 167. This is order dated.
That is order written, my lord, that is 38, 2023.
2023, 38.
WPC 4604, 2019.
2023. Okay, what has happened at page 167, direction?
The taking into account into my lord order dated 23/11/2007 passed in by the division bench in this court in WA numbers 20. The Department of the Forest and Environment, Government of Assam, as well as the private respondent are permitted to bring to the notice of Deputy Commissioner Morigaon any further development in respect of Pavitra Wildlife Sanctuary and more particularly order dated 20 passed in Supreme Court in 20. And kindly see the my lord direction of the my lord writ appeal. What was the direction, my lord? That is my lordship.
No, the first direction is that the revocation of no objection was set aside.
Yes, my lord.
That means the no objection was still there. And he was to decide afresh with regard to the no objection certificate so issued after considering the report from the stakeholders. Okay.
And giving opportunity to hearing the petitioner as well as the private respondent.
Now, was this done? Has this been done?
No, not been done. That has not been done, my lord. Then lordship, before lordship, kindly see the order passed in writ appeal number.
Page
lordship. That is, my lord, page 150, relevant page 153, my lord.
153.
Yes, fine. 153.
Yes, please.
That is the joint application, my lord, for the petitioner respondent, and that is the my lord, this thing to be considered. Kindly see, my lord.
Just a minute, please. WA is, what is the number? 361 or 301? What is the number?
Well, 153, my lord.
No, WPC, WA.
Read appeal, my lord, 241, 2017.
241, 17. 241 or 17.
Third paragraph, my lord. Paragraph, page 153.
153,
Yes,
third
ma'am.
paragraph.
From third paragraph, it is started.
Yes.
Third paragraph.
This is 23, 11, 17.
Yes, 153, two appellant. As you see, two appellant.
Yes.
Here
Now
in
let us come to the directions part.
that is it, my lord. See, for the referee, then turn to lost page 154.
Now, why do you go back, Mr. Barua? After the division bench order, matter had come up before consideration.
Yes, my lord.
There is an order of 38/2023
Yes, my lord.
directing for reconsideration of the aspect of the no objection certificate.
Taking into consideration the direction passed in, my lord.
WA. Now, has anything been done?
No, that has not been done. That is kindly turn to my lord impugn order. What the DP has done.
Yes, page.
Page, my lord, 169, annexure 19.
169.
169, my lord, annexure 19.
This is the impugned order.
And that is the impugn order.
Yes. Yes, what has been stated?
That whereas, for the fourth paragraph, my lord, and whereas Pollution Control Board Assam, only my lord, relevant portion, my lord, Assam Bomini Milan Guwahati Students has been issued to consent to establish certificate for establishment of BPPA Big Clean owned by so and so, dated 25/10/2011. And whereas the NOC had been given to establish the state Big Clean by the Agriculture Development Officer Raja Mayang Star from Morigaon and Gao Control of the state area, and also by the Secretary Mayang Gao Panchayat so and so, dated so and so. And whereas this Honorable High Court, Guwahati High Court, has directed the Deputy Commissioner Morigaon to decide the matter regarding the issuance of NOC for the state Big Clean for giving ample opportunity for hearing of the petitioner as well as the private respondent, and taking into account of any recent development of the Procedural Wildlife Sanctuary, particularly to the other order passed by Supreme Court of India in PN Godavaran. And whereas the Ranjasthan had issued notice to the petitioner as well as private respondent number so and so, dated so and so, for hearing on so and so, and whereas the perusal of the report submitted by the Circle Officer Mayong Revenue Circle file later dated so and so, the distance of the state Big Clean from Pura Mayong Reserve Forest is 1212 meter, and from the periphery of the Pavitra Wildlife Sanctuary is 2130 meter, and fulfill the all norms laid in Assam Big Clean Establishment Zone 2013. And whereas as per a report of the Divisional Forest Officer Nagaon, Division filed letter dated so and so, the notification in regard to the eco-sensitive zone in respect of Procedural Wildlife Sanctuary is under process and not finalized yet. In consideration of the above facts and reports submitted by all the stakeholders, the undersigned hereby reinstate the NOC dated so and so 2/9/11 and for establishment of BBA thing, he will adhere to obey all rule regulations so and so. Only when taking into consideration of the report of the circle officer. The retable order was there to taking into consideration the report of the agriculture officer, district forest officer, and also by the pollution control board. That is not they have not taken they have not taken into consideration.
Why the preceding page at 169? First, there is a finding that is industrial class land. Number 2, fourth paragraph.
No,
The PCB has given the consent to establish. Then the agriculture officer.
No, agriculture, I annexed the report. Agriculture report or agriculture officer report said that if we allow to establish a big thing, it will adversely affect the cultivation, petition, a report I have annexed,
No,
scientifically asked for the report, and they have not ordered, there no order has been called for,
No, the reports have been considered.
No, that has not been reported considered, And
That is your contention, but the prima facie reading of the order at 169.
Where is the report? Only sir, where is the report? Only DC report say that only the that
If you say there is no report, we have to ask for the report. If there is a mention about 2 reports, one of 29/5/2020.
That is prior to 2017. That is
No, that is of 29/5/2023.
So can you see that is no. Well, that is where that report NOC given
Okay, we'll examine. Yes, you are for.
Well, and for the forest department, in the main proceedings, I had objected because there was if I may be allowed to submit, the honorable court, had a portion, Lordship, I'd like to point out.
Of which?
Of the read order, at page 160. 5. I had taken reports to TN Godavarman, the Supreme Court had directed, where there is no EHJ has been proposed and been received, 10 kilometers has to be maintained. But the honorable court, my lords, at page page 166, my lord, para 7. Para 7.
No notification.
Well, still then there's an order of 30 June 2022 of Justice Anirudh Bose, my lord. It goes back to that original order wherein, my lord, the EHZ notification, if not received, my lord, 10 kilometers have to be maintained. It was pointed out, my lord. So invariably, my
So
lord.
this objection is only for the case of the respondent, private respondent. What about the other bricklins?
Well, as of now, my lord, we don't have knowledge of other bricklins. Only this bricklin is before us.
Okay.
Even the report
anything else?
Even the report of the DFO, my lord, at page 170.
Okay, we'll take care. We'll take care of. Yes, PCB, your report is 2011. Consent to operate. Isn't it liable to be renewed from time to time?
Yes,
Renewed. When was it renewed? Last.
My brothers, I think we so this is a return order. So
It is for 3 years. 3 years normally. 3 years. Yes, Mr.
3 months it is given primarily to see whether it possesses something or not.
Okay.
And to caveat that all rules, everything has to be maintained. Now also it is maintained. Now it is only for 3 months till June it is given.
Okay.
Normally,
Okay.
for a period of 1 year.
1 year. Every year it needs to be renewed. Okay.
Right?
But this is a very temporary kind of a permission for 3 months.
3 months.
Okay. Heard. 3 Arbor Learned Counsel for the petitioners. Full stop. Para. The petitioners, who are 10 in numbers, claim to be cultivators and are aggrieved by an order dated 19/2/2024 passed by the District Commissioner, Morigaon, in respect of a brick clean by the respondent number 12. 12. Full stop. It is submitted that there has been a series of litigations concerning the said Bricklin and with the primary contention of the petitioners that the same is being established without following the due process of law. Full stop. Sri Barua, the learned counsel, has drawn the attention of this court to the order dated 30/8/2023 passed by this court in WPC number so and so, page 167 declaration, wherein a direction for reconsideration of the aspect was given to the Deputy Commissioner, Morigaon, full stop. The said order had also referred to an earlier order dated 23/11/2017 of the Honorable Division Bench in WA 241 of 2017. Full stop. Para. By referring to the impugned order dated 19/2/2024, the learned counsel for the petitioner has contended that the order has not taken into consideration the relevant aspects and certain reports which have become obsolete have been referred. Full stop. It is contended that operation of the Bricklin would not only adversely affect the interest of the petitioners, but would also be a hindrance to the environment, which is adjacent to the Pobitora Wildlife Sanctuary. Full stop. Para. Issue notice. No. Three. Who is there?
But I am for my daughter to speak.
Who is for respond number 1?
1, 2, 6, and 7.
3. G. Gogoi, learned standing counsel, Forest Department, submits that though there is no order till now pursuant to the directions of the Honorable Supreme Court in the case of T.N. Godavarman with regard to the Pobitora Wildlife Sanctuary, the observation of the Honorable Supreme Court in such cases is that a distance of 10 kilometers is required to be maintained. Full stop. Para. 3. S. Barua, learned standing counsel, Pollution Control Board, however, submits that as per instructions, the no objection certificate, the consent to operate certificate was issued by following the due process of law. Madam, your Ms. S. Sharma, learned State Counsel, has supported the impugned order and has submitted that the same has been passed by taking into consideration all the relevant factors and by application and by due application of mine. Madam Bora, for who are you?
District Editor.
What do you say? Anything at this stage? No. If you don't have instructions, don't rely on him. You're okay. We will not say anything. Para, let the notice of motion be issued, returnable on 6th of May 2024. D. Gogoi, learned Standing Council Forest Department accepts notice on behalf of respondents 1, 2, and
6, 7.
6, 1, 2, 6, and 7. Ms. Sharma, London State Council for respondents 3 and 4. Ms. G. Bora for respondent 5. 3. S. Barua, London Standing Council PCB for respondents
8, 9, 10.
8, 9, and 10. Union of India. Union of India, NCGC.
But the name of super task can be
CGC.
Yes.
DJ Das.
DJ.
Shri DJ Das, CGC for respondent by 11. 3. BP Bora, Learned Council, who appears on the strength of a caveat, appears for the respondent by 12. Full stop para. ऊपर में लिखो नोटिस में Sri Bora, Sri BP Bora, the Learned Council for the caveator oblique respondent number 12 has however submitted that there are many other bricklins in the area against which there no complaints whatsoever has been raised by the petitioner, and only the bricklin of his client has been targeted. Full stop. It is further submitted that there is the permission to establish and operate the bricklin has been granted by all the statutory authorities, and he has also placed before this court a consent to operate dated 21/3/2024 issued by the Pollution Control Board Assam, as per which such consent is given for a limited period of 3 months, in which further scrutiny would be done. Full stop. Para. उसके बाद notice of motion. Let extra copies, huh? Within 2 days. List this matter on the returnable date.
Only thing was till from 2000 have not been operated. Only this time allowed to operate. Only the various order passed by this honorable court. That is my only one of the cultivator that is taken into consideration. And it is within the ecosystem. Since 2012, my lord, they will not be allowed.
Let us see. Give a copy of this 3 months. Okay, we'll retain the original. We'll give a copy. We'll retain it in the.
And my lord, and ask them to pass any one of what other big thing, my lord. That will
name at page 65 of the earlier petition.
You bring it on record.
Yes, I'll
name the big thing, my lord.
Take your time. Returnable till the returnable date file affidavit.
Yes.
Okay, next.
Before my alignment start, I have a preliminary objection to maintainability the respect and before petition. Because the original order was passed by the Assistant Commissioner at Agartala. Although appellate authority is Guwahati, but
The appellate authority has passed orders, isn't it?
yes, original order was passed by the Assistant Commissioner Agartala.
That appellate authority's order is not
The
a subject
notice
matter.
for the entire notice, the appellate authorities in Guwahati.
The appellate authority's order is not a subject matter of challenge. It is.
They have challenged both the order.
Yes, so that territorial jurisdiction will not come.
My lord, Article 226,
No, that-
part of clause of.
We are not on that. You submit whatever you want to.
But in this matter, my lord, I have challenged the order in original as well as the appellate order, my lord.
Correct.
The appellate order was dismissed only on the point of limitation. So, my lord, I have challenged the order in original also on various points.
Oh, yes, where is it? It's by the, which authority?
My lord, the appellate authority is ordered.
This is under the CGST.
CGST 1080.
It is a service tax matter, my lord.
Finance Act 99.
Appellate authority's order starts from 108. The order passed by the Commissioner Appeals, CGST, Central Excise and Customs.
What is the limitation prescribed for preferring an appeal?
But the limitation was 3 months from the date of the order plus 1 more month, my lord.
4 months.
4 months.
Is there any provision for condonation of delay?
My lord, only up to 1 month there was a provision.
Okay. When
So
did you file?
It was filed with a delay of 118, my lord, 135 days.
There is no provision for further condonation.
There is no provision, my lord.
So that is why you had also challenged the order in original.
That is why, my lord. Yes.
See, if the law does not contemplate even any provision for condonation of delay, then your approach to the appellate authority by filing an appeal was almost like approaching an authority without jurisdiction. So he may have a point that only to come to this court, if the appellate authority had applied its mind, given a finding, we may examine that, but we do not have the scope of examining because admittedly there is a delay.
Yes,
and there is no provision for condonation.
Yes, my lord.
Now, if there is no provision for condonation, you don't know the law. These are special laws.
Yes.
Unless Limitation Act is applicable in a general law, these are having a self-contained provision. That 1 month is the...
No, my lord, I will show, my lord, 2 judgments of Madras High Court and Andhra Pradesh High Court that even if suppose, my lord, there is a the limitation period for testing the appellate authority's order is expired.
Yes.
But the original order can be tested on the ground of principle of natural justice, also on the ground of jurisdiction.
You're Mr. Saraf.
Yes, my lord.
Mr. Saraf, we are not saying, even for a minute, that we cannot examine the original order.
Yes, my lord.
We can, but his initial objection of the territorial jurisdiction may have an
no, my lord, my point
impact.
is that the appellate authority's order is passed within the jurisdiction of this High Court. And my lord, the part of cause of action, my lord, why I have come to this court is that the appellate authority has passed an order against me. So against that order, my lord, as well as the order in original, I have come. So part of cause of action of dismissing my order in original has, my lord.
Saraf,
Yes, my lord.
if you contend, let us test your contention so far as arising of a part of cause of action.
Yes, my lord.
Only because of the involvement of the appellate authority's
Correct.
order.
Correct.
Do you have even a single ground of challenge of the appellate authority's order?
No, my lord.
You don't have a ground.
No, I don't have it.
You cannot just make a way to approach this court by filing an appeal, then come here.
No, my lord, I could have gone to Tripura High Court or my lord. My lord, so it is not that.
We can issue notice, but we'll have to have that maintain point open. It's up to you whether you approach the Tripura High Court. It's up to you. Because tomorrow the point might come. Normally, at the initial behest, first instance, we said that there may be a cause of action. But once it's pointed out that the decision of the appellate authority is not on merits and you do not have any scope of challenging that.
Yes, my lord.
Except that it has come through a particular channel. If there was any application of mine on merits, then no problem. It's a continuation of the order passed by the original order, then appellate authority, then we can examine. We can still examine. 226, of course, we'll examine the original order. But whether this High Court will have the territorial jurisdiction, that is one issue.
Well, my point is that the authority who is having the overall supervision over the entire northeastern state, it is based in Guwahati. So if any action is taken by the lower authority's action is, well, overall the direction is, or the authority is sitting in Guwahati, my lord.
Cannot be accepted. You're a military person working in Rajasthan. Union of India has an authority. You come to Guwahati. Will you accept? Union of India, Ministry of Home Affairs.
No, my lord, that way, I have not
Same
gone to
analogy.
Delhi. My lord, overall, to my lord, the CBI
Same analogy.
chairman is sitting in Delhi.
Why this High Court? Why not Delhi High Court? Just for the sake of argument. See, issuing notice is not a very difficulty for us, but tomorrow you have to answer. issue notice and you think over. We'll keep this point open. If you want to withdraw later on, you can. But don't delay in taking a decision. You're otherwise also late in approaching the court.
If your lordship permits, then I can withdraw and file in the
I
Tripura.
think that would be the best course. That would be the best course. We'll make some observations so that you don't have a problem in Tripura High Court.
Yes, yes.
Otherwise, that High Court might say it.
Yes.
Appellate court is in
Yes,
Guwahati.
yes.
Another point.
You don't allow him to withdraw.
No, Lordship, I am, because Lordship, some text has not been placed before a Lordship. Lordship come to page 1.
He's withdrawing.
No, that is all right. But Lordship, this should be fair to the court also. Their appeal was dismissed on 2 counts. One on delay, another they failed to deposit the pre-deposit amount that is mandatory.
Okay.
No, that is something, my lord, which he sought help from the officer because he is not so technically well versed. The law expired 5 years back.
See,
So
that-
it is on record, my lord.
See,
My
that-
letters are on
see-
record.
What is the separation of material facts? It has been clarified. Separation is material facts which we cannot even decipher from reading of the petition.
No, that is all right.
But
that-
what is
No,
there in
it
the
is
petition?
there part of the record. I have submitted letters which is also part of the
See,
record that I
you have
could not-
already cornered Mr. Saraf and you are trying to again put pressure upon him. Okay, heard. You are V. Sharaf,
Yes, my lord.
learned counsel for the petitioner who has put to challenge an order in appeal bearing number to the dated 2012-2023 passed by the Commissioner Appeals CGST, Central Excise and Customs. Guwahati, as well as the original order in original bearing number so and so dated 10/10/2022 passed by the Joint Commissioner, CGST, Agartala, by which, no, full stop. By the said by the order in original, a demand for an amount of rupees 47,24,701 has been raised on account of service tax, Swachh Bharat cess and Krishi Kalyan cess, along with interest and penalty for the financial year 2016-17. Full stop. It is contended that the endeavor of the petitioner to get his grievance redressed in the appellate stage being unsuccessful, the instant petition has been filed. Full stop. Para. 3. S.C. Kyle, the learned senior standing counsel, CGST, has, however, raised a preliminary objection on the ground that the order in original has been passed by the Jurisdictional Commissioner of Tripura at Agartala. Full stop. So far as the appellate authority is concerned, he has submitted that the appeal has not been decided on merits and rather has been decided on the grounds of limitation as well as non-deposit of the statutory amount. Full stop. Para. This court has considered the aforesaid aspects. Full stop. It transpires that the time prescribed for preferring an appeal is 3 months. 3 months or 90 days. What is the expression? 90 days.
Before the appellate authority, it was 60 days. 60 days plus 1 month.
60 days. Is 60 days, which is extendable by a further period of 30 days.
30 days.
30 days. And there is no specific provision for condonation of delay. Full stop. In that view of the matter, the other aspect as indicated is non-deposit of statutory deposit, statutory amount. Full stop. The aforesaid aspects cannot be termed to be a decision which touches the merits of the case as raised by the aggrieved petitioner. Full stop. Under such circumstances, comma, assuming jurisdiction by this court only because there is an involvement of an appellate authority at Guwahati may not be proper. Full stop. At this stage, comma, Sri Saraf, the learned counsel for the petitioner, submits that in view of such observation, comma, he may be allowed to withdraw this petition and file it before the appropriate High Court. Full stop. Para. In view of the aforesaid submission, comma, writ petition is allowed to be withdrawn with liberty to approach the appropriate forum. Full stop. It is further made clear that no observation touching upon the merits has been made by this court while dismissing the present writ petition on its withdrawal. Full stop.
May I please?
Yes, revenue.
Here, my lord, I'm seeking an interference of this honorable court, my lord, against the malified action of the police authority, my lord. Here, my lord,
Why revenue? Why revenue is there?
the police authority, my lord, without, my lord, registering the FIR, my lord, though it is disclosed a cognizable offense, my lord, they have registered a FIR under 107 CRPC and submitted a report before the district revenue, my lord. This is a malified action of the police, my lord.
Why malafide action? What malafide?
My lord, the 107 speaks about the, my lord, preventive in nature, my lord. This regarding, my lord, to prevent the breach of peace, my lord. And the FIR, my lord, disclose the cognizable offense, my lord, which is a penal in nature, my lord.
We'll issue notice at this stage. Anything to say, madam? Heart free as Bothakur learned counsel for the petitioner. Full stop. It is the case of the petitioner that he had lodged an affair on 24/1/2024 regarding alleging forgery in a sale deed number 1121 dated 11/2/1976.
Yes, my lord.
You are making a forgery after how many years?
My lord, sorry, my lord, I purchased a
Your allegation of forgery after how many years?
No, my lord, I have purchased a land, my lord. And thereafter, what had happened with the response number 6, my lord. In the meantime, came in the picture, my lord. And he said that, sir, I am possessing a land, my lord, on the basis of that sale deed, my lord. And he got able to got me to that, my lord. Then I have inquired, my lord.
Sale
It
deed
came to
dated
my knowledge that
11/2/1976. Full stop. It is contended that though the offense alleged is a cognizable one, comma, the same was taken to be an application in which section 107 of the CRPC was invoked and no investigation as such has been made. Full stop. Para. Let notice be issued. Do matters pertaining to non-registration of FIR and lack of proper investigation may not be entertained by this court, comma, may not be normally entertained by this court, comma. In this case, comma, a response may be necessary from the respondents. What's the para? Accordingly, let notice be issued, returnable on 8th of May, 2024. Home Department, yes, Madam S. Sharma for the State Council for respond numbers 1 to 5. Additional Deputy District Commissioner Revenue, 5. I think 5, Mr. 1 to 4. Okay. 1 to 5. That extra copies by tomorrow. Steps for service of notice. This one was 6 by registered post-daily by tomorrow. Take steps by tomorrow. There's a private respondent.
Yes, sir.
Registered post-daily.
Okay.
My lord, in the year 1996, a plot of Sarkari selling land, my lord, was settled with the petitioners. Thereafter, my lord, in 1997, the possession was handed over. The Jamabandi also recorded the names.
Okay.
In 2011,
You were landless people or what?
no, my lord, at that point of time, I was, my lord. I have a land now, but then the difficulty is that.
No, at that time.
At that time.
You were landless.
My lord.
So the ceiling surplus was given to you.
My lord.
Okay.
My
Now,
lord,
what
now,
has
my
happened?
lord, in 2011-12, in the settlement officer, the settlement operation, my lord, my name from the revenue record vanished, my lord. They said that, okay, we'll consider it in the integrated land management system. Even thereafter, it did not happen. So, my lord, even though I am occupying a plot of land right in the zoo road, my lord, as of now, the
Where is the
record-
settlement? Where is the settlement order?
Settlement order is at page 11, annexure 1, my lord. The premium was also paid thereafter.
Page 11.
Page 11, my lord, annexure 1. Premium was taken thereafter, my lord, at annexure 2. And at annexure 3, my lord, the possession was also handed over to the concerned circle officer. And at annexure 4, my lord, at that point of time, the Jamabandi was also, my lord, corrected.
Yes, madam. Heard Sri Pathak Learned Council for the petitioners. Full stop. It is the case of the petitioners that settlement of certain ceiling surplus land was made in their favor by an order dated 12/12/1996, whereafter their names were also entered in the revenue records. Full stop. However, the grievance of the petitioner is pertaining to the aspect that their names are not there, are presently not there in the revenue record, for which representations have been filed, which have not been acted upon. Full stop. Let notice be issued, returnable on 10th of May 2024. G. Hazarika, Standing Council, Revenue Department. One and only one.
Only one.
And
Two is the
Hendrick
tax
State
return.
Council 2, 3, and 4. Extra copies by tomorrow. Okay. You take instructions on the representation aspect. 20.
Here in this lordship, we have a limited grievances in this petition lordship.
Yes.
Father of the petitioner lordship had 51 bigha of land. And that out of that land lordship, 27 bigha, 2 kata and 17 lesser was made ceiling surplus. That was made in the year 1976. Without the lordship, that was not within the knowledge of the present petitioner. And father of the petitioner lordship expired in the year 1991. My lord, in the year 2022, when they can approach the authority for recording their name lordship in place of their father, they came to know that the land has already been made as a government land because of ceiling land, surplus land. Thereafter, lordship, we filed a representation before the government, and government lordship after that asked the authorities of the BTC authority to get back the report. Accordingly, lordship, the report has submitted. But the decision is not yet taken, lordship. If your lordship kindly comes to or representation.
Let us see the report.
My lord, the report that is circle officer report lordship page 23,
2-3.
my lord. And that was submitted to the government page 24. The land is still under our possession. Page 24 is the communication to the government.
Now, first, can you challenge an action taken under the ceiling surplus
My lord,
after a period of 30 years?
my lord, that is correct, but that land is
What
not,
30 years? 76, what 30 years? 40, almost 45 years.
my lord, in the report, your lordship kindly there is the last paragraph.
The report has nothing, there is nothing, neither here nor
The
there.
land, my lord, petitioners are totally unaware about this ceiling surplus.
Being
the
unaware, will not, first, whether you can challenge, if you can challenge, whether you have done at a reasonable point of time.
My lord, because we are not aware about the lordship.
You are still in possession.
My lord, we still possession. That
Okay,
is the
take-
report
Take instructions.
in the last paragraph of the report itself. says.
Third, Sri M. Khan, Learned Counsel for the petitioners, full stop. Para. The projected case is that the father of the petitioner was the owner of a plot of land measuring 51 bigha, 2 katha, 17 lachas. Full stop. However, in the year 1976, an area of land measuring 17 bigha, 2 katha, 17 lacha.
27.
You've written 17.
27 bigger, 2 kata, 17 lakh.
27 bigha, we have said. 27 bigha, 2 katha, 17 lacha.
Lot.
We have read, said 27 bigha only. 17 lacha, we have said.
Yes, yes.
27 bigha, 22 katha, 17 lacha.
Well.
Under DAG number 150/268 within bracket new. Patta number 15 was made ceiling surplus, which the petitioners contend that they were not aware. Full stop. In the meantime, their father had passed away. Full stop. However, the petitioners continue to be in possession of the land. Full stop. On being aware, comma, a petition has been filed by the petitioners. Petition application has been filed on 23/9/2022, in which though a report has been prepared, comma, no consequential orders have been passed. Full stop. Para. Let notice be issued, returnable on 10th of May 2024. Three, Revenue Department, Miss Anne Baudelaire, Learned Standing Counsel, Revenue Department. Accept notice on behalf of respondent 1 and 2. Three, J. Hendrik, Learned State Counsel for respondent 3.
3, 5, and 6.
3, 5, and 6. Three, S.R. Abha, Learned Standing Counsel BTC for respondent 4. Let extra copies by tomorrow.
Master.
Item 21.
Ma'am, lordship. Lordship, matter pertaining lordship by interest portion lordship in connection the land acquisition lordship. So whatever lordship I have received the principal amount as on 12/12/2023 law. So lordship
How much amount have you received? What was the principal amount?
86 lakh 13,000 something law.
Okay, that was the principal. That was the principal amount.
Yes, the principal amount.
Okay.
So lordship, whatever in section 80 of the new fair act business plan defined lordship, so interest portion ought to be provided lordship along with the principal amount. Lordship.
The
So, lordship,
acquisition is by whom?
by the Water Resource Department and Deputy Commissioner lordship. Among all these around. Lordship, page 21 lordship. The kindly find lordship.
When was the acquisition done? When was the acquisition done?
Lordship,
So,
When was the acquisition done? Which
in the
year?
year of 2001, Lordship.
One. And when was this principal amount paid to you?
Lordship, 86 lakh, Lordship.
No, when?
In the month of December 23, Lordship.
Okay. You were claiming interest from 2001 to 2023.
Yes, Lordship, exactly.
Okay. Yes, Mr. Das.
Lordship, regarding the earlier writ petition, which was already been disposed.
Oh, there was an earlier writ petition.
Yes, Lordship. The Lordship, petitioner has filed several writ petitions. Lordship.
Several?
No, several.
Initially, Lordship,
In
that
disposing
part-
of this writ petition, he has filed a preferred and appeal, Lordship. In the appeal,
that part, Lordship,
just
We'll come to you, Mr. Das.
in writ appeal, he has filed 13 of 2024 writ appeal. In that writ appeal, Lordship, petitioner has annexed one letter, Lordship, one representation.
Lordship, that part already withdrawn, Lordship.
Mr. Das, we'll come to you.
Yes.
Don't worry.
Yes. In page 113 of that writ appeal, petitioner has addressed to the Honorable Justice to recalculate his fees. Response, Lordship. Lordship, may kindly have a good copy.
Lordship, that part already over, Lordship.
What has happened thereafter?
Finally,
Thereafter, what has happened?
Lordship, because of this, Lordship, he has withdrawn this.
withdraw this petition, Lordship.
After that-
Inadvertently, that case was appended with this writ appeal, Lordship. So therefore, Lordship, that writ appeal was withdrawn, Lordship.
That
Lordship.
letter has been written by my friend, Planet friend.
Lordship,
His name is there.
Lordship, whatever, Lordship, that part is my brother has wrongly appended that particular annex, Lordship. So that's why, Lordship, I have already withdrawn this writ appeal, Lordship. And the Honorable Court directed to the Deputy Commissioner, Lordship. I have submitted the representation.
This appeal was against which order?
The writ appeal was against the order of 18/12/23 that my learned friend has annexed in page 27, Lordship, but he has not mentioned this thing
Lordship,
about the writ appeal. Page 27.
27.
Against this order, my learned friend has prepared an appeal.
What was the direction in this order?
Direction to the approach before the Deputy Commissioner and under section 12 of the land acquisition.
The
Lordship.
direction was to approach the
So
deputy
thereafter,
commissioner
Lordship, I have
section 12.
approach before the Deputy Commissioner, Lordship.
Instead
and
of
the
approaching the deputy commissioner.
Okay.
So, Lordship,
Okay, did he approach?
Lordship, now he has approached, that is on,
Yes.
after that writ appeal, he has filed a review application also
Where?
before this honorable court, Lordship.
as
Review.
per the direction.
But that
Mr.
review,
Das, you'll have your chance. Sit down.
Sure. Yes.
Haven't you heard the court?
Yes.
We don't expect chorus in this
I'm sorry.
petition.
I'm
Why
sorry.
don't you maintain decorum?
I'm sorry.
If two people speak at the same time, whom will you listen to?
I'm-
Have your sit. We'll
Please.
hear you. Yes.
Lordship,
Review against which order?
review against this order, Lordship. This, my order. 18
Review before
18
the single bench.
No, before the division bench. That review also been withdrawn by my learned friend. After that, he had preferred an application, representation before the deputy commissioner on 8/3/2024. And now he has preferred this petition against this order, Lordship, 8/3/2024.
8/3/2024. What is the cause of action now?
Lordship, 1 month has just gone. Lordship, that
What is the cause of action, Mr. Das?
Lordship, whatever, Lordship, kindly find, Lordship, the page 21, Lordship, is a
21.
honorable, yes, Lordship. Order dated 9/10/2023, Lordship. This honorable report is added, Lordship, in as
21, yes.
Lordship, there are number 5, Lordship, page 21, Lordship.
Yes.
May I read, Lordship?
Yes.
From a perusal of the section 11 of the Assam Land Acquisition and Requisition Act 1964, it is stipulated that the compensation would be paid in terms of with the Land Acquisition Act 1894. Subsequently, in view of the notification which has been issued by the Revenue and Disaster Management of the Government of Assam, it is stipulated that the compensation would be paid in terms of the right to fair compensation and transparency in the Land Acquisition, Rehabilitation, Resettlement Act 2023 in respect of the acquisition made under the Act 1964, Lordship. Next paragraph, Lordship, kindly find, Lordship. Paragraph number 6, Lordship. In both the
We have read this, Mr. Das. See, against this order, he had gone to the division bench. you had withdrawn. Review file withdrawn. Then pursuant to the said order, he had approached the deputy commissioner only in March, 8th of March.
8th March.
Today is only 1 month. Why do you want a direction now? There is already a direction of the single bench. Where is the scope of passing another direction?
Lordship, what happened here in this case, Lordship, the Honorable Supreme Court held one of the full bench judgment, Lordship, the Monholal case, Lordship. So, which is clear defined, Lordship, as section 24 subclause.
We are not on the merits, Mr. Das. We are on your action, your conduct. Why are you flooding this court with litigations like this?
Lordship,
Where is the cause of action?
Lordship, let me finish, Lordship. So, that particular judgment, clear defined, Lordship, para number 366.5, Lordship. So, the section 80, which is clear defined as new act, Lordship. So, the department provided the principal amount along with the interest portion.
Mr. Das, for a moment, have we said anything regarding your entitlement for interest?
Yes, Lord.
Have we said anything that you are not entitled or entitled? It has already been decided by the court. You are asked to approach the deputy commissioner. You have, when have you applied? 8-3.
8-0.
And you have approached this court when? By filing this when? On 3-4. Today is 8-4. Within a month.
Yes, sir.
Why do you want a direction?
The petitioner is about the 75 years old, Lordship.
How much cost are you going to pay?
80.
How much cost are you going to pay? Leaving it to you. How much cost?
75 years old.
75,000. Don't laugh. It's not a question of laughing. How much cost?
One thing is the Lordship.
How much cost?
Lordship, the petitioner is about 75 years old.
Heard. 3 RC Das.
Lordship, the Lordship, representation not to be
for the petitioner. Full stop. Also heard. 3 RM Das, Understanding Council, Water Resource Department, and Miss Anne Bordelot, Learned Standing Council, Revenue Department. Full stop. 3 J. Hendick, Learned State Council, is present for the state respondents. Full stop. Para. Our board Procedural Finance Department. Para. As per the facts projected, comma, certain land of the petitioner was acquired in the year 2001, which is in the district of Dorang. Full stop. The petitioners, in connection with the compensation for such acquisition, comma, the petitioner had earlier approached this court by filing WPC 4942 of 2021 for a direction for payment of interest and solicium. Full stop. It is on record that the principal amount of rupees 86,13,601 was received by the petitioner and accordingly filed an order dated 29/11/2023, comma, the order dated 18/12/2023, comma, the writ petition was disposed of by giving liberty to the petitioner to approach the District Commissioner Darang to seek a reference. Full stop. Para. The operative part of the order is extracted herein below, page 27, taking into account of a last. Full stop. The petitioner claims to have submitted a representation in this regard only on 8/3/2024, and a prayer has accordingly been made in this petition for making payment of interest which has been quantified, which has also been quantified. Full stop. Para. On the other hand, comma, Sri R.M. Das, the learned standing counsel, Water Resource Department, has submitted that the writ petition has been filed by suppression of material facts known to the petitioner. Full stop. It is submitted that against the order dated 18/12/2023 of the single judge, comma, writ appeal 13 of 2024 was preferred, in which a communication was also annexed, whereby an application was made directly to the honorable judge for recalculation of the interest amount. Full stop. Though the aforesaid writ appeal has been stated to be withdrawn, comma, the same was against the same, comma, a review application was also filed, which was also withdrawn. Full stop. This court has noticed that these facts have not been revealed in the writ petition. Full stop. Para. Apart from the aspect of suppression of material facts, comma, this court has noticed that the application to the Deputy Commissioner Dorong has been stated to be filed only on 8/3/2024, and within a period of less than a month, comma, this petition has been filed on 3/4/2024. Full stop. Para. While on the one hand, comma, the broader issue of pendency of cases in courts is one of the major concerns, comma, frivolous litigation of the present nature is one of the factors which have led to such increase in pendency. Full stop. The final order of the single judge is dated 18/12/2023, by which, comma, liberty was granted to the petitioner to make appropriate applications. Full stop. The petitioner chose to prefer an appeal, being WA 13 of 2024, annexing therein irrelevant and extraneous documents. Full stop. Though the appeal has been said to be withdrawn, comma, the petitioner had thereafter filed a review petition against the aforesaid order of withdrawal. Full stop. It is only after such withdrawal of the review petition, comma, the petition before the Deputy Commissioner Mongoldoy Dorong was filed on 8/3/2024, and as indicated, comma, within a period of less than a month, comma, the instant writ petition has been filed. Full stop. Apart from the fact that the writ petition is held to be premature, comma, there appears that the approach of the petitioner to a court of equity has been done with unclean hands and without any bona fide purpose, full stop, para. The writ petition is accordingly dismissed with a cost of rupees 25,000 to be paid to the so-and-so.
Lordship, we do respect, Lordship. So we
Yes,
are
next.
binding, Lordship, we are binding the 141,
Next
Lordship. We are binding Article 141, Lordship. The Supreme Court has, Lordship. So on that basis, Lordship, I have filed a writ appeal. And there
Further submissions before the appropriate forum, not here. We have passed orders.
Lordship, as per the direction of this court, Lordship, I have filed, Lordship. The cost, Lordship, what to be withdrawn, Lordship.
Yes, next.
Masalah.
Before my colleague would start, I filed a bar on number 4, court respondent. But I would ask for a copy. I had not filed a caveat.
Okay, doesn't matter.
No.
Tomorrow,
Not tomorrow.
Day after tomorrow, my lord.
Would it be on the reopening for the reason, my lord?
you are asking for an interim order.
My lord.
What
Then
kind
day
of,
after tomorrow.
what
My
kind of
lord,
interim order?
My lord, president of the cooperative society was, my lord, suspended, my lord. And in appeal, my lord, he was, my lord, suspension, proceeding of the meeting was cancelled, my lord.
You are for the president.
Yes.
A specific case was,
You are for the president.
they cannot be
Okay,
two
well-
agents.
Okay, we'll have it tomorrow or day after.
Day after tomorrow, my lord.
Tomorrow also.
Tomorrow.
But can it be, it would have been better if it is on the reopening?
Tomorrow,
I also
tomorrow.
have to challenge the same order. I also have to challenge the same order, a part of the order.
Tomorrow you support your friend Meta and
We are in two other
you come
parts.
to this side.
Would it be with WPC
Okay,
6243, my lord?
You have already filed.
No, rather it is pending, which is the same, concern would be the same.
That is not a motion
Have a
matter.
bearing.
We'll tomorrow let us consider this, then we'll pass orders of tagging.
Lordship.
Heard Sri N.K. Kolita Learned Counsel for the petitioner. Court of Para. Also heard Sri G. Bodola Learned Standing Counsel Cooperation Department. Full stop para. Sri Bonik, as Bonik, Learned Counsel, however, informs that he has filed the power of appearance for the respond number 4. Full stop. He accordingly prays for some accommodation.
Would it be day after tomorrow?
As
Tomorrow
you
I
see-
file my petition, what comes together day after tomorrow?
Okay, and as requested, come on, let this matter be listed for motion. When?
10th.
10th.
Acknowledged.
May I please your lordship? My lord, the petitioner before my lordship is a my lord registered association, my lord, which is operating the transport business of the buses, my lord, for the carrying of passengers. My lord, we have been accorded permission also to my lord a particular plot of land, half kilometer interior to the my lord national highway. So my lord may be pleased to find the permission is at page 40, my lord.
লাগি আছে কিয় কিন্তু বেলেগকে লাগি আছে কিয় কাটি যাব খোৱাত listen you can proceed. Yes, you are a registered union.
My lord, we are a registered association, my lord, operating the bus transport business with passenger carrying vehicle. And the my lord Bukakhat Town Committee has also allotted a plot of land with due permission to my lord park our vehicles in that area, my lord, particular area, just my lord half kilometer interior to the my lord bus stand, my lord, half kilometer interior to the national highway. My lord may be pleased to find our permission, my lord, is at page 40.
Yes, 40.
40, my lord,
Okay.
Annex 7. Let's go. Lord, permission is hereby accorded to the president.
Yes.
Yes, my lord. And
4817.
my lord, yes, page 40.
4817.
48/2017, my lord. And since then we are operating. And my lord, what has happened as my lord, the place is interior to the national highway. So therefore, my lord, what has happened? They have given a permission, my lord, to park two numbers of vehicles, my lord, in the national highway side, my lord, as a parking, not for, my lord, for the purpose of operating rate placed as a stand, my lord, but only to pick up and drop off, my lord, the passengers that pays 40 to annex 8, my lord.
Yes.
Now, my lord, what has happened by taking records of as our buses had been, my lord, allowed to park in that particular place, the private respondent has come in, my lord, and a series of buses, my lord, has been, my lord, started parking there.
Who is private respondent?
Private respondent I have made, my lord, is the respondent number, my lord, 9 and 10, my lord, is the All Gulaghat Public Bus Owners Association and the Bokakhat Besarkari Bus City Ride and Traveler Malik Sanstha, my lord. And the private respondent 12 is also involved. My lord, this person do not have any permission, my lord, whatsoever. Neither they have a permission as a to operate as a bus stand or as a parking lot, my lord. So, my lord, what has happened? We have submitted complaint also, my lord, before the authority. because-
Yes, madam.
My lord.
I am formal party here, my lord. Neither transport have issued any permission, neither we have.
Yes, Deputy Commissioner.
Bokakhat and-
Okay.
Take for this matter.
Thank you, sir. Private respondent.
Who is respondent number 11?
My lord, respondent number 11 is the, my lord,
Why have you made him party by name? Individual?
Rebo Das. Who is Rebo Das? My lord, who is managing the respondent number 10? Respondent number 9 and 10 has been, my lord, has been managed by this Rebo Das, my lord.
No, 9 and 10, they have been made parties. Why?
Parties, my lord. Or, my lord, we can, my lord, if my lordship allows out, my lord, we can strike him out also.
Striking off is not a
My
easy nowadays. Okay.
My lord.
Third, Sri A.R. Bhuya, Learned Counsel for the petitioner. Full stop. The petitioner, which is an association, petition number 1, which is an association, in the name and style, Bokakhat, Honmilita, Jatribahi, Bas Malik Association, is aggrieved by the actions of the private respondents by parking their vehicles in the allotted slot
My
for pickup and drop point, which was given to the petitioner
Petitioner.
association. Full stop. Para. It is the case of the petitioner that initially vide a permission dated 4/8/2017, the concerned Bokakhat Town Committee had permitted a parking space to the petitioner association, which is about half kilometer from the national highway.
My
Full stop. To facilitate and ease the and facilitated the passengers, a pickup and drop point for 2 numbers of buses was also allowed in the national highway via a permission to the petitioner association. Full stop. However, taking advantage of such permission, the respondent numbers
9 and 10.
9 and 10
My
have been parking their vehicles
Right.
without any permission.
Yes, ma'am.
Not only, which is not only illegal and is also causing
Traffic congestion. my lord.
congestion in the national highway.
My
Full stop. Para. It is this cause of action which has been espoused in this petition. Full stop. Para. Let notice be issued. Returnable on 6th of May 2024. Miss M.D. Bora, Learned Standing Council Transport Department accepts notice on behalf of respondent 1,
2
2,
and 3.
3. Whereas Sri
4 to 7.
J. Handik, Learned State Council accepts for respondent numbers
4 to 7.
4 to 7. Extra copies by tomorrow. Steps for service of notice under 8, 9, 10, and 11 be taken by registered post with AD. Steps by within 2 days.
My lord.
Deeply obliged.
But may I pray for an interim order on the return of the check? Malik.
Obliged.
Obliged.
Item 44, supplements.
Lordship, with a deep apology, Your Lordship, I am seeking some accommodation in this case today, Your Lordship. Because, Your Lordship, I could not go to the file, Your Lordship. I was.
Motion, you don't have time to go through motion.
Lordship, I was out of station, Your Lordship. Today morning.
You don't need time
Lord.
to prepare for motion.
Sir, because there are a lot of facts here in this.
When? After the vacation? You had got it by order.
Lordship, that's why I am seeking.
You have to pay some cost.
Lordship. It is.
Bihu time. Association needs some. Your association.
It is under compelling circumstances. Your
Why do you use?
Day after tomorrow.
Why do you misuse the memo?
Lordship.
Mention memo.
Lordship.
For misuse of mention memo.
No, Your Lordship, because what has happened, Your Lordship, I was supposed to reach Your Lordship yesterday, Your Lordship. That's why, Your Lordship, they
Then
have mentioned it, Your Lordship.
Remedy by cost.
Lordship, day after tomorrow, Your Lordship.
2 days. Tomorrow less cost. Day after tomorrow more cost. Today no cost. At 2 o'clock.
Lord. At 2 o'clock, Your Lordship.
At 2 o'clock. You don't need 1 hour to go through a petition.
Lordship.
2 o'clock.
Lord.
What is this case?
In fact, Your Lordship.
That Pirala subtomatter, Lordship judgment is already covering the field, whereby my lord, the earlier writ petition filed by the so-called landowner, that has been dismissed by this honorable court, by your lordship.
Yes, yes.
Here, Your Lordship.
And again.
Near Bohori.
Lordship. Here, Your Lordship, we have challenged that order of the Your Lordship Revenue Board, Your Lordship. Saying that, Your Lordship, the issue before the Revenue Board was, Your Lordship, in respect of 19 bighas and odd land, Your Lordship. But the Revenue Board passed an order, Your Lordship.
Okay, at 2 o'clock.
Lord.
Okay.
Item 26 and 27.
Transport Department.
My lord.
Affidavit filed.
Lordship.
You have filed rejoinder also, Mr. Mohan.
Rejoinder, probably.
Yes, you have filed. In 836022,
Yes.
you have filed rejoinder. What is to be done? Okay.
It is only for the remission part, which already the tender period is over. So in the last occasion.
Remission, is it permissible under the rules?
Yes, my lord. This is a rule, my lord. It is permissible.
But
So ground is, my lord, that within the 3.2 kilometer of the either side of the any, my lord, shuttle ferry service, no, my lord, the other ferry service who is carrying the public service that we continue, my lord. So in my case, when it is admitted fact, that the 4 ferry services, it is run under by the Gwalpara Jilla Parishad and the Matia Ancillary
If you want the matter to be finally considered, we can have it today. After maybe second half, it will take some time.
Lordship, at 2, I have one matter fixed.
No, 2 o'clock, there is a, we will have that motion of Mr. Botakur after that.
But my lord, in their petition regarding remission, they have said during the panchayat operating their part, they are losing some revenue. That may be bring on record. What is the difference between now their earning?
You are settled by whom? The Transport Department?
Yes, my lord.
Your settlement was by the Transport Department.
No,
And
my,
in
my
areas,
settlement was by Transport Department. The other police service, that is by the Jilla Parishad and under the panchayat.
in an area which is not under
Same
the-
is area, my lord, 3.2 kilometer area. That is, my lord, forgotten as per the provision of 35 people in front of police. So this is, they have to calculate, my lord, whatever I have lost, and I may be allowed to give the all the details of the my, this is records, whatever is also they are maintaining. So difference can be calculated, and as per that, my lord, they can give the remission. This is the fact, my lord.
My lord may remand the back to the director IWP.
Because, my
We
lord,
will
in
take it
similar
further.
circumstances, our High Court, my lord, has given an order in other writ petition. So that benefit is also given to the other writ
Okay,
petition.
we'll have this in the,
Lordship,
in the second half.
they kindly accommodate me.
Yes, yes. You, maybe after the motion on 2 matters, then we'll take up your. matter.
Lordship, Lord. I will
Whenever
discuss the-
both of you are there.
Well,
Obliged.
Okay, the next two. Yes. Mr. Burwa, what is this?
My lord, your lordship of High Court order dated 18/1/23, my lord. Court has taken judicial notice, my lord, at paragraph 3, my lord. Regarding, my lord, may I read it, my lord? Referring to the stone memorial house indicated in the photograph at page 37 of writ petition. It is submitted by the Learned Standing Council for NC Hill that the said memorial has been taken over by the Archaeological Survey of India long back, which is not included in the land acquired by NC Hill. In the interim, the court is inclined to direct that before dismantling the projected wall and bridge Girard, the authorities of NC Hills Council shall take photographs of the area sought to be cleared by them in respect of the land acquired from the petitioner.
Yes, have you done so?
Nothing has been done, my lord. I have filed affidavit.
We have filed our affidavit, Lordship. The affidavit we have said is that he has been paid the compensation regarding what he has claimed.
Okay.
No, no, my lord. Here we are claiming the Girard. In their affidavit, kindly see paragraph 6.
Paragraph 5, Lordship. May kindly refer paragraph 5.
Now, are you satisfied with the compensation part?
Land compensation, we are satisfied.
No, Girard part, you are not being paid.
Not a single payment has been done. In fact, court has
So,
directed them.
Mr. Das is more concerned with the Girard part.
Lordship. Lordship, regarding that, Lordship, we have already stated, Lordship, in paragraph 5, Lordship. If your Lordship permit me.
Please read.
Lordship, for the damages of Girard.
Okay, we'll come back after in the second half.
Lordship.
This petition, your lordship, the petitioner says, your lordship, challenge an order, your lordship, passed in the year 2005 by the Board of Revenue.
2005 order.
Your lordship, why it has to be filed, your lordship, at such a belated stage is, your lordship. 2005 order, your lordship, that is at page 134, your lordship, of the writ petition. Your lordship will find the dispute, your lordship has already, your lordship has passed detailed order on this issue, your lordship. Here, your lordship, the dispute, your lordship, was in respect of 17 bighas of land, your lordship. 17 bigha 2/6 acres of land covered by DAG number 318 of Nispikeras Patta number 1, your lordship. Now, 6 persons, your lordship, applied for settlement of those lands, your lordship, claiming to be riots, your lordship. On that basis, your lordship, settlement was granted. Now, that was put to challenge, your lordship, by the one of the, your lordship, one Dipendranath Goswami, claiming it to be a land belonging to Pirolata. Now, your lordship, in this, if your lordship comes to page 135, your lordship will find that there is a specific reference that in brief that respondent number 5 to 10 applied for ownership right over an area of 17 bighas 2/6 acres of land in that number.
Yes.
Now, your lordship, ultimately when the board, your lordship, decided the issue, your lordship, way back in 2000, it gave a finding, general finding, your lordship, that this particular land of the entire plot of land, your lordship, is, your lordship, belonging to, your lordship, the Nispikeras Patta land, your lordship, and belonging to, in fact, your lordship, religious institution, your lordship. It does not say specific terms that it belongs to Pirola Satra, but it's the finding at the page 140, your lordship will find 140. From the theta of the suit land available in the case record, it is seen that the patta of the land is Nispikeras Patta, of half revenue estates originates from the land given by the Ahom kings, which later came to be known as Dharmotter, Devotter, and Brahmotter land. Therefore, it cannot be disputed now that land is not Satra land. The proviso to section 515A of the Assam State Acquisition of Lands belonging to religious and charitable institution of public nature Act 1959 as amended states that notwithstanding anything contained in the Assam Land and Revenue Regulation 1886, the right of transfer of land belonging to above mentioned institutions for a riot shall only to a person belonging to same religion in which the ownership of land was vested. Here it is seen that so-called tenants who were given to ownership right by this convention belong to another religion, therefore granting ownership right of Satra land to persons belonging to a religion other than that of the person to whom such belong is not permissible. Now, your lordship, since 2005, your lordship, the matter remain as such. We are not parties to this proceeding, your lordship. Now, only when your lordship an eviction notice was issued, your lordship, in the meanwhile, your lordship, prior to issuance of the eviction notice, your lordship, one of the your lordship, the descendant of this Goswami, your lordship, he, your lordship, came before this honorable court, and this honorable court, your lordship, dismissed this writ petition, your lordship, which now is your lordship before the honorable division bench, your lordship. That your lordship's order is page 167.
He had
167.
challenged which order?
He has challenged your lordship an order. Your lordship will get it page 167. Page 153, your lordship will get the order which was put to challenge in the writ petition. It is regarding correction of land record of Pirola Satra as per order passed by the honorable. Now, your lordship, in 2005, your lordship, the order has been passed, your lordship. And in 2022, 11/4/2022, your lordship, the revenue record was corrected on the basis of that order, your lordship. Page 153, your lordship will find.
Let us again see the subject matter of challenge of 3003.
Your
22.
lordship, your lordship will get it, your lordship.
150?
153, your lordship.
153.
This is the order, your lordship. Court order 153 is the order which was put to challenge, your lordship.
Yes.
Lordship. That was put to challenge, your lordship, and this honorable court was pleased to, your lordship, reject their petition, your lordship, and thereafter, your lordship, an eviction notice was issued. In these proceedings, your lordship, we were not parties, your lordship. Eviction notice, your lordship will get it at page 174.
174. 174, yes.
Now, this is, your lordship, based on your lordship's order, your lordship, in WPC 3003 of 2022. Now, your lordship, at that point of time, your lordship, the petitioners preferred WPC, your lordship.
Okay.
That is, your lordship will get it at page 178.
178.
Your lord.
You,
this case is presently pending.
you had filed this same
petitioner.
Same petitioners.
They have only challenged the eviction notice in that petition, your lord.
Yes.
Now, your lordship, this case is presently pending, your lord.
Yes.
Now, so far as your lordship's order is concerned, your lordship, that is challenged by the writ petitioner, your lordship, as well as by the present petitioners by taking, your lordship, leave of the honorable court, your lordship. That is also pending, your lordship. Those two writ appeals.
Another petition has been filed.
No, your lordship's order in WPC 3003, your lordship.
Yes.
That was challenged before the division bench,
Okay.
your lordship, by the petitioner as well as the writ petitioner of that particular case, as well as the present petitioner, your lordship.
Okay.
By taking leave of the, those two appeals are also pending, your lordship.
Against 17/1/2023.
Lordship. Now, your lordship, here, your lordship, after, your lordship, these proceedings were going on, your lordship, we find it, your lordship, appropriate, in the very basis of the order on page 11/4/2022 is the order passed by the Board of Revenue, your lordship, in the year 2005. Therefore, your lordship, we have put this to challenge the present petition, your lordship. Our basic ground is, your lordship, is that we were nowhere parties to that proceeding, your lordship. Without hearing us, your lordship, without being party to the proceeding, your lordship, probably, your lordship, the Board of Revenue ought not to have passed an order, general order, your lordship, number one, your lordship. Number two, your lordship, is this, your lordship, the order specifically referred to your lordship specifically referred to the Act of 19 of your lordship, Assam State Acquisition of Land belonging to religious or charitable institution of public interest, 1959. Now, the applicability of section 15 of that particular act will come, your lordship, only when your lordship land will be acquired, your lordship. There are provisions, your lordship. The section 3, your lordship, says there are issuance of notification, your lordship. And section 4 says, your lordship, consequences of the notification.
The initial order, which is the subject matter of 18/7/2005, was this a subject matter of challenge in any other proceedings
No,
earlier?
Your Lord. No, Your Lord. This is for the first time, your lordship, we have put to challenge. Your Lord. Some of the your lordship affected parties, your lordship, they have in fact filed, 6 of them have filed a review petition there, your lordship. But that is also pending, but we have directly.
When was the review filed?
Review was filed, your lordship. I have annexed, your lordship. Page number 205. 205. 205 and 6, your lordship will get. These are pending, your lordship. These are 2023. Since your lordship, the present petitioners, your lordship, and all other affected parties except the 6 who were, your lordship, the parties to the first proceeding before the Board of Revenue, your lordship, came to know about this, your lordship, only on your lordship issuance of your lordship the eviction notice, your lordship. Therefore, your lordship, ultimately they have preferred in your lordship. And that's why, your lordship, there is delay in challenging this, your lordship. And apparently, your lordship, it is only in the year 2022, the government has, your lordship, acted upon, your lordship, the order of the Board of Revenue, your lordship. Now, your lordship, at this stage, your lordship, today, your lordship, I don't have any interim prayer, your lordship. Our prayer is, your lordship, for issuance of a notice, your lordship, and let them come up with the affidavit, your lordship, on these issues, your lordship, and the matter may be taken up along with the other writ petition pending, your lordship. This is what we are praying for, your lordship. Now, otherwise also, your lordship, on merit, there are the 2 grounds, your lordship, that we are not being parties to the proceeding. And secondly, your lordship, so far as this act is concerned, applicability of section 15 also is concerned, your lordship, it will be applicable only when there will be acquisition by the government, your lordship, of land belonging to charitable trust, your lordship. Now, your lordship, thirdly, your lordship will kindly see the judgment of the Assam Board of Revenue. Your lordship will find that there is no specific finding to 2 aspects, your lordship, whether it is a dharmottar, devottar, or your lordship, brahmottar land, your lordship. Now, for being, your lordship, will be a land allotted to your lordship to a institution of religious character, your lordship, it cannot be brahmottar, your lordship. It will have to be, your lordship, dharmottar, your lordship. Or that finding is also not there in this writ petition, your lordship. In this particular, your lordship, order. Without that finding, this order has been passed, your lordship, which in our humble submission, your lordship, it has prejudicially affected. We cannot place our case before the authorities, your lordship, or the learned Board of Revenue, your lordship.
Who are you?
We are, your lordship, your lordship, we claim ourselves to be riots, your lordship.
Riots of whom?
Riots of your lordship will kindly come to this. It was not in the name of Pirala Satro, your lordship, in the revenue record.
Okay, riots of whom?
Riots of your lordship. Originally, we were riots of Narendranath Goswami, your lordship. Page 77, your lordship will get it. There are 5 pattadars, your lordship.
Of Narendranath Goswami.
Lordship, Rajanikanta Goswami.
No, you are riots of whom?
Rajanikanta Goswami, your lordship, Bhuban Chandra Goswami, Dharanidhar Goswami, Aurobindo Goswami, and Adjournment Goswami, your lordship.
Those 7 petitioners. Those 7 petitioners.
Those 6 as well as we, your lordship. Because there is one single patta, there is, your lordship, that has not been, your lordship.
No, you are how many?
Now we are 90, your lordship.
90 are riots of whom?
In this, belong to your lordship, originally belong to your lordship, Rajanikanta, your lordship.
No, where have you stated? You are riots of whom?
Lordship. Your lordship, I will. We have submitted, your lordship, riotic quotients, your lordship. Quotients were also issued, your lordship.
Where?
Lordship. Page 130, your lordship.
130.
113, your lordship.
113.
These are your lordship. Annex of 5, your lordship.
Where are the originals?
Original, your lordship. What is original?
Your rights of whom?
Lordship will kindly say names 115.
Yes, we have seen that. Rights of whom?
Your lordship, Pottadar Viboron, your lordship. Rajani Goswami, Aurobindo Goswami, Adjournment Goswami, Bhuvan Chandra Goswami, Dharani.
This belongs to whom? Who is the righty here?
Your lordship, this is one Motleb Dewan, your lordship. And Motleb Dewan is your lordship the আমি put statement করেছি মতলব দেওয়া না কোন কোন Your lordship will get your lordship in annexer 1 page 51 who are the ancestors your lordship we have mentioned in detail your lordship page 51. Motleb Dewan, your lordship will get it at page 52. Serial number, your lordship, 31.
You claim yourself to be riotees or the descendants of the original riotees?
That is good.
And what was the ABR judgment?
Lordship.
ABR, what did the ABR say in 18/7/2005?
ABR says that this is, first of all, your lordship, this land belongs to Satra. And since we belong to different religious groups, your lordship, under section 15 of the Act, your lordship, we are not entitled to get settlement under that.
Okay. Yes.
My lord, may be pleased to come to page 167. That is my lord's judgment on the earlier round of litigation.
167.
167. Now the petitioners claim, my lord, that they are the legally inducted tenants of one Rajani Goswami.
Correct.
Now kindly see, my lord, if my lord comes to page 168 for that matter. Who was before this honorable court in that earlier round of litigation?
Yes.
It starts from 167, WPC 3 Hirondo Kumar Goswami. Lordship may kindly come to paragraph 3 of my lord's petition.
Yes.
The petitioner is the legal heir of one Rajani Goswami. So they claim to be the owners. They are the riots. So-called riots, my lord, purported riots. And this Rajani Goswami, and for that matter, the petitioner, that is the Hirondo Kumar Goswami, they are the purported owners of that plot of land. Now, under that section circumstances, what is the finding of this honorable court? What my lord has pointed out.
Okay. Where?
Kindly come to my lord, page 173, paragraph 14.
14.
14, my lord, page 173.
Yes.
Without there being a specific challenge to the basis of the impugned order dated 11/4/2022. Now, this was the order by which my lord the records were sought to be corrected. This court is not even required to look into other aspects of the matter. This court also finds force in the submission made by so-and-so in that the order dated 11/4/22 was already acted upon and the correction made on 6/5/2022 and the subsequent action has not been put to challenge. The question which the state has raised doubting the bona fide of the petitioner in instituting the present case in absence of a specific denial is also a relevant factor which this court has considered. On a specific query, this is important, the learned counsel for the petitioner has submitted that the petitioner is a teacher and therefore by no means can be assumed to be personally cultivating the land in question, wherein the provisions of Article 31A might come in. In any case, the state protection is only in the matter of acquisition of land and not for making the land encroachment free, and therefore recourse to the constitutional provision is not at all applicable in the instant case. This court also finds sufficient force on the argument of learned Advocate General Assam that the Act of 1959 provides for an appeal, and in the instant case, the petitioner was agreed by the provisions of the Act. He can prefer an appeal under Section 21(3). Under the aforesaid circumstances, this court is of unhesitant opinion that there is no merit in this writ petition, and therefore the same is dismissed. And prior thereto,
Yes.
prior thereto, if my lord may be pleased to come to paragraph 8 of the judgment, page 170.
Yes.
So and so, while acknowledging that though the affidavit in reply has been filed, there is no denial at all of the allegations doubting the bona fide of the petitioner in instituting the present case. In the course of argument, Sri Kotoki Learned Counsel for the petitioner has also referred to a communication issued by Circle Officer Sengar Revenue Circle, wherein the satras existing under the said regulation were named, which were Sri Horidev Satra Bahari and Sri Srimanta Sankardev Horidhua Ghat Patra, Senga, and there was no mention of Pirola Patra. The Learned Counsel for the petitioner submits that the state document would substantiate his first submission that there was no Patra in the name of Pirola. The process submission is also dealt with by the Learned Advocate General by stating that while the communication relied by the petitioner is of the year 2019, there are communications of later period, including which started from a petition dated 14/6/21 submitted by the Patradhikar, amongst others, the Pirola Patra. Then at paragraph 9, my lordship has recorded the submission. Then paragraph 10.
Yes.
The Learned Advocate General Assam has also placed before this court an additional affidavit filed on 19/1/23, wherein excerpts of the interim report of the Assam State Commission for Review and Assessment of Problems of Patra lands in Assam dated 29/10/22, as well as final report dated so and so by the Committee for Protection of Land Rights of Indigenous Peoples has been put on record. On perusal of the records, the existence of Pirola Patra and the fact that the same is under illegal occupation clearly comes out. So this is the finding of this honorable court. Now, after having, my lord, dismissed that writ petition, these subsequent exercises have come into existence, my lord. They are now perturbed. Now, lordship may kindly see, I'm troubling my lord with all these pages. Lordship may kindly come to page 205 of the writ petition.
Two zero five.
205. Annexure 14, my lord. This is an order passed by Assam Board of Revenue in a review petition. Page 205. Lordship will kindly see, my lord, this order is dated 35/2023. Subsequent to, my lord, dismissal of that writ petition by this honorable court. And this review petition has been filed, my lord, seeking a review of that order, 18/7/2005. These are only, my lord, convenient afterthoughts in my respectful submission, of course, my lord.
Review against.
And then lordship may kindly come to the next page, 206.
Okay. This is filed by whom?
This is filed by
Some
Mohammed
other
Quddus Khandakar and others. How the petitioners are linked, my lord, they had every knowledge, my lord, I will demonstrate.
Okay.
Page 206, my lord, is an appeal by the same person, Quddus Khandakar. Now, this is an appeal not, my lord, against that original order dated 18/7/2005, but this is an appeal, my lord, of that, my lord, record correction order 11/4/2022. 11/4/2022 was, my lord, negated by this honorable court. Challenge to this order dated 11/4/2022 was negated by your lordship in that writ petition. Notwithstanding that fact, notwithstanding, my lord, that finality of, my lord, the decision, this appeal has been preferred. Now, whether this appeal is maintainable, my lord, I am not on that. Now, lordship will kindly come.
Just a minute.
My lord.
Yes.
And in page 206 itself, lordship will kindly see their conduct, my lord. Their
206.
206. That is the appeal. Appeal against order dated 11/4/2022, which was negated by this honorable court.
That was not negated. We had said that was not the subject matter of challenge,
Subject matter, my lord.
which is the basic order, and
Basic
therefore
order.
the correction order you cannot challenge.
Yes. Now, my lord, that order stands.
Okay.
Now, that order has been put to challenge, and it was put to challenge in a very hurried manner. Kindly see, my lord, that's what I am pointing it out. Page 206.
Yes.
This is order dated 35/2023.
Yes, yes.
Learned advocate for the review petitioner is heard partly on the point of it. During the course of hearing, learned advocate for the applicant has prayed for time to amend the memo of review petition. Now, these are the same set of parties, and the order is dated, my lord, the same date, 35/2023, page 205 compared with page 206.
Yes. Amend the memo of review petition. That means the other one.
Yeah, the other one.
New respondents.
The respondent.
Okay.
Now, the primary ground taken in the instant writ petition is that, my lord, the petitioners did not have any knowledge about passing of that, my lord, initial order dated 11/7/205 by ABR, since they were not parties. Lordship, for a moment, my lord, may we please to come to page 141. Let us see the array of parties. Who were the, my lord, respondents? 141.
141.
141. That is the original photocopy, my lord. I am relying on the original photocopy.
Yes, yes.
Yes. There are 141. Lordship will kindly see, my lord, the array of parties.
Yes.
Petitioner is Dipendranath Goswami, the
Yes.
purported landowner, and my lord, the respondents are Deputy Commissioner, ADC, Circle Officer. My lord, the respondent number 5, Atwar Rahman.
Atwar Dewan.
Atwar Dewan. Atwar Dewan. Lordship will kindly mark this, and my lord may be pleased to come to page 12 of the instant writ petition.
Page 12.
Page 12. Atwar Dewan. Atwar Dewan was a party respondent. He had every knowledge of that proceeding. At page 12, petitioner number 58. Petitioner number 58 is one Idris Dewan, son of Atwar Dewan. Claiming under him. That's it, fine.
Lordship, so far as these two review petitions are concerned, your Lordship, in this
One is review, one is appeal.
appeal, your Lordship, that, your Lordship, we have not filed those petitions. We are not aware about that, your Lordship. We have not preferred this. What they have challenged, that is not our concern. So far as your Lordship's order is concerned, which he has been referring to, your Lordship, we have put that to challenge before the Honorable Division Bench, your Lordship. Now, therefore, your Lordship.
Where is that case?
Lordship. Read appeal, your Lordship.
Yes.
Lordship. Page 207.
207.
Lordship. That is the order in which, your Lordship. Page 221, your Lordship, the relevant page.
Those two read appeals are listed tomorrow, my lord, before the Honorable Division Bench.
Now, two read appeals are, your Lordship, presently pending, your Lordship. Tomorrow, both of these two are coming up, your Lordship. Now, essentially, your Lordship, we are One 170.
You are the same petitioners.
Where, your Lordship? Yes,
In the
your Lordship. It is
IA and-
appeal. These 90 petitioners are, your Lordship, before this Honorable Court, your Lordship, by present petition, and also read appeals, and also, your Lordship, the eviction notice he has put to challenge. They have put to challenge. So far as they are concerned, 3 petitions are presently pending, including this. And therefore, your Lordship, my prayer is, your Lordship, ultimately, your Lordship, the case is that they have been evicted, they have sought to be evicted from a land where they have been residing for years, your Lordship, since 50s, your Lordship, prior to that also, your Lordship. Now, your Lordship, we are at least entitled to some kind of, your Lordship, notice of, before that, your Lordship. The Board of Revenue passed order, we are not parties to that proceeding. In 2005, Revenue Board passed an order, the authorities, government, your Lordship, acted upon it in the year 2022, your Lordship. Even before that, your Lordship, had they put us to, your Lordship, notice that this is the order, and your Lordship will kindly note, your Lordship, although they have relied on the order of the Board of Revenue order is not specific, your Lordship. That's why, your Lordship, we are saying that, your Lordship, let us, your Lordship, at this stage, at least, your Lordship may issue a notice and let them come up with an affidavit, your Lordship, bringing all these facts, including what they have submitted today, your Lordship, and both this matter and the other may be taken up together, your Lordship. That's my humble submission, your Lordship. And in fact, your Lordship, when in a case of this nature, your Lordship, they will be prejudicially affected, they are at least entitled to some kind of notice, your Lordship. Either on the side of the administration, your administrative, your Lordship, or judicial, your Lordship. In both ways, they have not been given a notice. And the record reveals, documents reveals, your Lordship, that they could come to know about this only in the year 2022, your Lordship, when the eviction notices were issued, 23, when eviction.
Your submission does not, is not reflected from your conduct, is looking different, it's not consistent. ABR judgment of 2005 affecting your rights, you are not a party, and you say that till 2022 you are not aware.
Yes, your Lordship, unless
one of your group goes to the ABR,
Lordship,
one group comes to the High Court.
Lordship, maybe your
Are you
Lordship.
trying to frustrate the orders of the court?
No, your Lordship.
It appears that is your intention.
No, your Lordship, that cannot be, your Lordship. Will kindly see, your Lordship. Your Lordships, when passed the order against in the petition filed by the Goswami, your Lordship.
We are not convinced that you are not aware.
No, your Lordship.
These are matters that are concerning your right to livelihood, and you are not aware of 2005.
No, your Lordship, how could I, your Lordship? From the documents, your Lordship, it reveals that your Lordships cannot take presumption, your Lordship, that we are aware, your Lordship. We cannot remain aware. Unless there is a notice, your Lordship, by them, by some of the authorities, how could we, your Lordship? In 2005 onwards, your Lordship has seen that government is also
You
sitting.
cannot also presume that you are not aware.
Yes, your lordship, because your lordship, there is no documents to show that we are
Is
aware.
the document necessary for all
Yes,
cases?
your lordship.
For all cases?
No,
To know about this ground reality?
no, your lordship, ground reality will be your lordship even only once they have gone for
Your
your
conduct
lordship.
is not consistent.
No, your lordship, let them, your lordship, come up with at least an affidavit,
Not
your lordship.
necessary.
That's what your
Not
lordship, my
necessary.
submission is, your
Not
lordship.
necessary.
Because your
In
lordship,
cases of this kind, I don't think,
your lordship will see,
we don't find bona fide.
your lordship can see, your lordship, we are coming, your lordship.
We don't find bona fide.
Your lordship, in the entire documents, your lordship, if in a single documents the respondent can show, which shows your lordship that we are aware, your lordship, in any way, then your lordship, I admit that I don't have any case, your lordship. Only ground of delay we can be challenged, your lordship.
We'll dismiss this.
Lordship.
We'll pass detailed order, but we'll dismiss this.
Lord.
We may impose cost also.
Lordship will kindly see, your lordship, we have come, your lordship, some people has come before this honorable court, your lordship.
We grant relief to person who are deserving.
No, your lordship, that
And
your
who
what
can
has
make out a case.
Fallen from your lordship's mouth is, your lordship, your lordship.
These are very, very matters of great public importance.
No, that's
some
what
few persons are trying to raise an issue of Khotro land.
No, your lordship will kindly see, so far as eviction is concerned, that they can
If
at
you
any
make out a
point of
case,
time.
yes, if you make out a case, why not?
They can, your lordship, but there is a procedure laid down, your
Your
lordship.
conduct is not appealing to this court. Okay, next case.
Deeply obliged, your lord.
I'm so obliged.
We'll record your thing. You have done we'll record your submissions.
Lord. And only thing, your lordship, that cost part, your lordship is always, your lordship can dismiss, your lordship, if we fail to convince your lordship. But your lordship, these people have come with a legitimate grievance, your lordship. Therefore, your lordship.
You're forum hunting.
Lordship.
Forum hunting.
No, your lordship.
One person goes there.
No, if
one
I would
person
have gone
comes.
there, your lordship, then again coming there,
It's not a
withdrawing,
question
then
of,
withdrawal would
it's
have
not a
been.
question of you or this particular petitioner. You form a group.
No, that your lordship, so far as in these kind of cases, your lordship, we cannot say they have come as a, they
Some
can be
things
termed as a
some
class,
things
your
can be
lordship.
presumed.
No, your lordship, presumption, your lordship cannot.
You are
be,
aggrieved. You are aggrieved. You are one group.
No, your lordship.
You try various
With
formats.
utmost humility in my command, your lordship, I am submitting presumption probably cannot be the ground of.
You are trying to hit everywhere. If you get any relief somewhere, it's not
Lordship,
like that.
that cannot be forum
It's not like
something,
that.
your lordship.
It's not like that. Yes, next.
Deeply obliged.
কোনটো মানে কি আছিল এটা আইটেম নাম্বার 26 27 28 ও এটা শুনিছিল ট্রান্সপোর্ট কি আছে এটা ট্রান্সপোর্ট 26 আর মিস্টার মহন্ত
Here the settlement period is over on 31st.
Remission part.
Only for remission, but that part also the highlighted that remission part will be later on decided, my lord. So for that reason, my lord, this case will be lifted.
But who will decide this? The state authorities, not the transport department, I think.
Remission.
Remission will set department, transport department, my lord.
Transport department.
Yes.
What is your instruction?
So, Director Lordship, we have filed our affidavit.
Yes.
Have a look. The affidavit filed in WPC number 6521/2023.
There are two writ petitions, similar, Mr. Mohanta.
Yeah, my lord.
Both the writ petitions are
Yes,
similar.
first one, my lord, that was actually, there was a specific order from this honorable court to file a representation, and direction was given to the director to take a call on my grievances. So
Yes.
after filing this representation, that was rejected, that we are not entitled for revision. So this second petition was filed.
Oh, that means it's the legality, validity of that order, which
Yes,
is.
well, that is spoken
Then
order.
we hear you. If what, let us see the order.
The Lordship will find the order at page 56.
In the second read, 6521. Let us
My lord.
6521.
This is annexer 16 at page, my lord.
Page?
Page, my lord, 56, man.
If and only then, this.
Actually, whatever was highlighted in the order of the honorable court, nothing was whispered in this speaking order. Nothing was taken into account.
Please read this.
My lord,
Please read this.
my lord, yes. This is peruse the petition of the Abu Said Mandal, Lanet Budrushar Vasantapur Lesi, Budrushar Vasantapur Ferry Services dated 24/7/2023, as well as the order of the Honorable Guwahati High Court dated 19/7/2023 in WPC number 63998 of 2022. Tender was floated for settlement of the Budrushar Vasantapur Ferry Service for the period 2022-24. Filed under tender notice memo number latest 28/6/2022, and the base value of the ferry service was fixed at rupees 2,15,625 only. It is expected that the period of it is expected that parties who buy to take on lease the ferry services to make an assessment of the field and thereafter got by taken all the factor into as consideration for operation of the ferry services as a profitable business venture. In spite of the speaking of the quoted estimate of rupees 2,15,625, this is only the bidder had quoted rupees 53,98,650, only with a which is 25 times higher than the base value. The bidder must have assessed the ground situation prior to the submission of his high buy. During the time of the tendering process of the Budrushar Vasantapur ferry services for the period 2020-24, the Ghat, namely Jaintapur to Udarisar Ghat, Vasantapur NC to Vasantapur, Salmari to Bahari NC Ghat, and Bohori Bazar to Bohori Part 2 were in operation of the Zilla Parishad, Gwalpara and Matia Development Block 1. On coming to know about this, some necessary communications were made by the Executive Engineer, Inland Water Transport Division, Guwahati, to the CEO, Zilla Parishad and PDO, Matia Development Block, to stop the operation of the above mentioned Ghat as per Rule 35 of the Control of Management of Ferry Rule 1968. In pursuit of the latter, the concerned authority took initiative to stop the operation of the above mentioned Ghat, and moreover, as per the report received from the concerned section in charge, all the above mentioned Ghats are presently in operation with effect from 2/7/2023 under the Budrushar Vasantapur ferry service, except Bahoti Bazar to Bahoti Part 2, wherein beyond the radius of 3.2 kilometers of the said ferry services. Since all the time the tender process, the above mentioned Ghats were operation by the local authorities, which were known by the petitioner, so the claim for remission does not arise. The writ petitioner is not entitled to reimbursement of the cost incurred in the construction of the foot bridges, bamboo bridges, as he has not taken prior permission from the Inland Water Transport Authority for construction of the same. By constructing the bamboo bridge, the lessee has operated the ferry service without operational expenditure of boat. Well, I am not on that with the ferry, well, regarding the boat.
You have constructed a bridge.
That was bridge, well, with the, because there is a specific provision is there. Because, well,
You charge the persons who cross over the river by the bridge.
Because, well, there was, well, no water to running the ferry service. So, well,
So you charge somebody who uses the bridge.
That was one of the with the knowledge that is also there in communication. It is specifically stated that we have constructed 2 bridges, 9 lakhs something, but I am not on that. If the construction is not paid for, I am not on that. But so far the remission regarding the operation of the 4 ferry services between 3.2 kilometers, which is specifically provided in 34 of the ferry rule 1968. So I am entitled. That is also I admitted, my lord. Kindly see their affidavit, my lord.
Let us see the ferry rules.
Yes, my lord.
Very nice again. Photocopy gold Rule?
Rule 35, my lord.
35.
Yes, ma'am.
No, that we know. Regarding the remission?
Remission, that is a remission, my lord.
Please read.
My lord. এখানে এখন আছে মতো। Yes, my lord. This is, my lord, recognized non-transport ferries only can run within the distance of 3.3 kilometer on either side of the ferry. The lessee shall have no claim for compensation of remission or refund of his money on this account. So, my lord, only the non-transport ferry service can be operated. So, my lord, in this case, all the ferry services is, my lord, transport ferry service. So, in the case of the non-transport, I have no right. But so far, the transport ferry services, that is a remission is entitlement. And they have admitted.
Where is these are there has to be an enabling provision. This is a restriction so far as non-transport ferry service is concerned.
Yes, my lord.
Where is the enabling provision? You cannot say that since there is nothing, so I am entitled to remission.
No, my lord, this
Remission is
is
something which is very positive in nature.
My lord, our High Court, in the similar circumstances, my lord, decided the case, my lord.
Yes.
And on the basis of kindly before that, my lord, I want to, my lord, show your lordship. And on the basis of that order, my lord, the remission has been granted, that has been relied by the respondent side also.
Yes. Please read which part.
My lord, this is only one copy, my lord, I got.
Which paragraph?
This is, my lord, the probably last paragraph, my lord. Middle paragraph, my lord. This is small judgment, my lord. Middle paragraph, my lord.
What is this order? Notice of motion and to stop the illegal operation. Where is the order of remission?
On the basis of that, my lord, they have passed the remission order, my lord.
Where?
I am saying, my lord. In the Alada writ petition, my lord, that was disposed of, my lord. This is copy is there, my lord.
Page
This is page 56.
of the repetition.
This earlier writ petition, this is 8360 of 2020.
Where do I get? Is it a part of the records?
Yes, my lord.
8360.
Page, my lord.
8360.
Yes, my lord.
The first writ petition.
Yes, my lord.
Page
Page, my lord, 56.
56. Yes.
And this is the
It is observed that
it is observed from this report of the executive in the Indian Road Transport Division Guwahati as well as the concerned junior engineer that the existence list of the Mukalma Bhangarmari ferry service has suffered loss due to the obstruction of the settlement of the ghat by the Barkhetri Anchalik Panchayat. The Honorable Guwahati High Court has taken the matter in this consideration and issued an order 30/10/2017 in WPC number 6393 to remove the Panchayat ferry services from the jurisdiction of the Mukalma Bangarmari ferry services. Accordingly, the listee has given the run the ferry services from 2011-2007. The settlement value of the ferry services was sustenance per year, rupees per day, and total collection of rupees sustenance per day. So loss of revenue is such amount, and accordingly, therefore, the total revenue loss for the date of the taking over the charge of the ferry service by the lessee is from 9/8/2017 to 30/10/2017 is rupees 4468.00 into 84 days. Total loss was 3,75,228. So that similar circumstances, the remission was given. So I am also, my lord, have a right to get the remission. So I may be allowed to file the representation and to make a consideration so that I may be in the how much.
Mr. Mahato, let us be very clear. There was no order of this court for remission. The authorities on their own had taken up this issue.
But the observation,
if they take up the issue, similar issue, so far as you are concerned, we have nothing to say.
But
on law, how do you justify your claim?
But the rule, my lord, saying 35 is specific, they only non-transportation, my lord. That means, my lord, obviously the meaning, that if it is
No, no,
transport.
Sorry, you are interpreting law. This is
No, my
not,
lord,
you
this is
don't go, you don't go by presumptions.
My lord, this is the.
There has to be an enabling provision.
My lord, kindly see, my lord. Their affidavit, my lord. In this.
We have already made it clear, Mr. Mahanta, that if they consider your case, we have nothing to do. But this consideration, taking the cue of an order, there is no order of this court, with all respect.
But
the court has only issued notice and said, do not make obstructions. Court has never even taken the issue of remission, not to talk about any directions.
But the department has, my lord, considered it that was an
If
order.
they consider in your case, what can we say?
But their affidavit, my lord, kindly see their page 65 in this.
Which one? Which one?
This is a later one, my lord.
Later one is
This is, my lord.
6521.
Yes, my lord, 6521, my lord.
Yes, which page?
It is 65. Annexure 2, their document.
65.
65.
Yes, please.
They are issuing the letter to the, my lord, concerned authority to stop the all ferry services, my lord.
That they have already stated.
It is, my lord. So that is why, my lord.
Stated.
So from the day.
4 have been stopped and one is beyond 3.2. So that was not stopped.
But this is a specific bar, my lord. My submission, this is a specific bar. The transport service cannot be even within 3.2 kilometers.
A specific bar, that is illegal. It has to be declared illegal. Then what is the
So on the
consequence?
basis of that, I may give for remission because when the order, the rule is specifically saying, if it is not in the manner non-transport, then I cannot claim for. But if it is a transport, I can claim for the remission. It is specifically, in otherwise, it is meaning by this.
Your interpretation we cannot accept.
But the rule, my lord, very clear, my lord.
The rules are before us. So
Yes, very clear.
Show the clarity in the rule. If you are submitting, just saying clear is not due. Show the clarity. What is the order? What is the rule? Tell us. No person shall establish, maintain, or work in a ferry to or from any point within a distance of 3.2 kilometers from the limits of a public ferry without the prior approval of the competent authority declared by the government under Section 13 of the Northern India Ferries Act, provided that recognized non-transport ferries only can run within a distance of 3.2 kilometers and no tolls can be levied on recognized non-transport ferries or on persons so and so. Lessee shall have no claim for compensation or remission or refund or kiss money on this account.
Yes.
Does it mean that for others you'll have a claim for remission? Where is the enabling section?
If it is, my lord, a transport, my lord, that's why I may have a right to, because within the 3.2 kilometer district. Then why this, my lord, they have stopped this, my lord, things, all the activities. Why this report was, because before
they have stopped because of Rule 35. Because Rule 35 says within 3.2 kilometers, no other can function.
My lord, kindly have
whether you get remission or not, that is up to the department. There is no law as such.
Kindly have a look the first order passed by the honorable court, my lord, in my.
Which proceeding? Which proceeding? Which proceeding? Which one? Second one?
This is for the second one, my lord. Yes.
First order.
First order. This is page 46, my lord.
46.
Yes, my.
Yes.
This, my lord, read petition 6521, my lord.
Yes.
Where my lord, my lord, while passing this order, the case of the petitioner into instant read petition is that the pursuant to the NIT dated successor, the settlement of the Budrushar Basantapur ferry service was settled with the petitioner by order dated successor. It further appears from the perusal of the read petition that the petitioner thereupon initially deposited the fixed amount of rupees cash security on Iman. Thereafter on Iman, the Budrushar ferry service was handed over to the petitioner by the.
Read paragraph 6.
Yes, my lord, this is 6.
6.
Yes, 6. That the court, upon taking into consideration of the respective contention and the more particularly taken into consideration the communication dated, their communication, my lord, dated 13/12/2022 and the 15/2002 issued by the section officer Budrushar Basantapur ferry services as well as the assistant executive engineer Inland Water Transport Subdivision Dhuburi Subdivision respectively is of the opinion that it would be the interest of the justice that the director Inland Water Transport take a call as to whether the petitioner would be entitled to the remission as well as the reimbursement of the cost incurred in the construction of the foot and bamboo bridges, under which the circumstances the court again fixed the matter again on and suspension. And by this time they had passed the.
So where is the direction to pay remission?
Nothing.
No, direction is not there. But direction was on the
He has
basis of their,
considered, he has passed.
there are two communication. My lord, kindly have a, my lord, this is annexed. There is a two, my lord, order. This is a communication. This is annexed 10, 11 and 12, my lord. No, 12 and, my lord. Yes, 12 and 13, my lord. No, 11 and 12, my lord. It is a page 43. It is by the sectional officer, my lord. This is addressed to the Assistant Executive Engineer, Inland Water Transport, Dhubri, my lord. With reference to the subject cited above, I have the honor to inform you that I have received an application from Abu Said Mandal.
Mr. Mahanta, no need of reading those. Let us pass something order which will try to consider your grievance. You do one thing.
My lord.
The office order, which is the subject matter of challenge 9/8/2023, has taken into some considerations which, in the opinion of this court, are not relevant. The ground realities, all those things are not relevant. If it is an illegality, it's an illegality. And 4 of the ferries, there was stoppage order. That means his allegation that somebody was obstructing is correct. So the question of payment of remission is not envisaged in the law, but there is an order which is relying that in one of the instances, you have done an exercise.
My lord.
If you think fit, you do the exercise, but these reasons which you have cited perhaps are not relevant, except the last one. You see, he has seen the ground reality, he has quoted high. Doesn't mean that somebody will illegally ply the other ferries within his area. That part we don't think that is proper. Okay.
My lord, may kindly
But they-
observe,
but they-
but in
but
the
they-
meantime, they may have also submit their documents showing that these are their,
They have already submitted documents. We'll do something else.
no, regarding the earlier order passed by the department.
Okay,
in the
yes,
earlier
you-
cases,
you
they
do
have
that.
to just do some exercise also.
You do that.
Yes, my lord.
No, I will submit everything, my lord.
No, not everything. The order which was passed by the department referring to a court's order, though the reference was not correct, but it is a matter of fact that remission was granted to some on such a similar allegation. You give the order, submit the order to them. Third,
And
CP
so far,
Mahanta.
my lord, this spoken order that is passed by the Inland Director, it is not any, my lord, whisper regarding the under what provision, under what line, my lord, that should be passed. Nothing has been whispered. Simply, my lord,
So that is
said
direction
that-
from His Honorable
Okay,
Court to dispose of the representation. That's why we have passed this
Okay,
order.
heard CP Mahanta, learned counsel for the petitioner. Also heard Ms. M.D. Bora, learned standing counsel, Transport Department,
For all the respondents.
for all the respondents. Full stop. Both these writ petitions which are filed by the same petitioner and are connected are being disposed of by this common judgment and order. Full stop. Please have your seat. The facts involved may be narrated in brief in the following manner. Para. Pursuant to an NIT dated 28/6/2022, the petitioner had participated in the process which was for settlement of the Buduchar Basantpur ferry service in the district of Gwalpara. Full stop. The ferry was accordingly settled with the petitioner at his bid price of rupees 53,98,650 wide and order dated 9/8/2023. Full stop. Para. It is the case of the petitioner that immediately on starting the operations, the petitioner could find that the Gwalpara Jila Parishad, Matia Anchalik Panchayat had given settlement of ferry services to 4 other bidders, 4 other 4 other persons which were operating within 3.2 kilometers of the petitioner's ferry service. Full stop. Alleging violation of Rule 35 of the Control and Management of Ferry Rules, 1968, within bracket hereinafter called the rules, the petitioner was compelled to suspend his ferry and had also constructed a 2-foot bamboo bridge and another wooden bridge for which expenditures were incurred. Full stop. Para. The petitioner had accordingly approached this court wide writ petition dated the first writ petition WPC 8360 of 2022. Full stop. Para. This court, after considering the facts and circumstances, had passed an order dated 19/7/2023 by directing the authorities, the Director, Inland Water Transport, to take a call regarding the entitlement to remission as well as for reimbursement of the cost incurred in construction of the bamboo wooden bridge, wooden footbridge. Full stop. Para. Consequent to the said directions, for any reference, the aforesaid direction is extracted herein below, page 41 of the second writ petition. Flag Maurice. Page 41. Paragraph 6. Consequent upon the aforesaid direction, the petitioner had submitted a representation on 24/7/2023, which, however, while order dated, which the represented 24/7/2023. Full stop. The aforesaid representation, however, has been rejected by the Director, Inland Water Transport, vide an order dated 9/8/2023, which is the subject matter of challenge in the second writ petition, WPC 6521 of 2023. Full stop. Para. Sri Mohanto, the learned counsel for the petitioner, has, by relying upon Rule 35 of the rules, has submitted that the embargo to claim compensation or remission or refund of kiss money is only for recognized non-transport ferry and certain other ferries, and not for illegal operation within the zone of 3.2 kilometers of the area of operation of the ferry allotted to the petitioner. Full stop. The learned counsel has also referred to an order dated is it 65?
Page 70.
Page 60s?
58, the earlier order. Page, annex of 17, page 58, last page of the petition, 6521.
Yes, the learned also referred to to an order dated 22/3/2018 passed by the Director, IWT, in similar circumstances whereby the loss was ascertained and remission made. Full stop. He has also placed on record the order dated 30/10/2017 passed in WPC 6393/2017, which has been referred in the order dated 22/3/2018 and accordingly praised for a similar direction. Full stop. Para. Per contra, comma. Ms. Bora, the learned standing counsel, has at the outset submitted that the order impugned dated 9/8/2023 has been passed pursuant to the direction of this court dated 19/7/2023 in the first writ petition WPC 8360 of 2022, and the said order is in consonance with the observation made by this court. Full stop. It is further submitted that the impugned order has taken into consideration all the relevant factors which are germane to the issue and has come to the conclusion that the petitioner is not entitled to remission. Full stop. The learned standing counsel has also submitted that Rule 35, which has been relied upon by the petitioner, does not envisage payment of any remission. Full stop. Para. The rival submissions have been duly considered and the materials placed before this court have been examined. Full stop. The first writ petition WPC 8360/2022, which was also on the issue of a claim for remission, was dealt with by this court, and in the order dated 19/7/2023, an observation for consideration was made. The said observation made in paragraph 6 is extracted herein below for the sake of convenience. Page 49, paragraph 6. Full stop. The consequent thereupon, the petitioner had filed a representation dated 24/7/2023, wherein justification for his claim has been made. Full stop. In that representation, reference to the order dated 22/3/2018 of the department passed pursuant to an observation. 22/3/2018 passed by the department in case of the Mukalmua Bhanganmari ferry service was also mentioned. Full stop. Tara. a perusal of Rule 35 of the ferry rules would show that within a radius of 3.2 kilometers of a public ferry, comma, no other recognized ferry is authorized to run, full stop. However, certain recognized non-transport ferry, along with some more specified categories, are allowed to run, for which no claim for compensation or remission or refund is envisaged by the said rule, full stop. The claim for seeking remission has to be on the basis of an enabling provision, and the contention made by the petitioner to rely upon Rule 35 for the said claim does not appear to be a correct interpretation of the said rules. Full stop. Having said that, having observed that, comma, this court, on an examination of the impugned order dated 9/8/2023,
Page 56.
it would show that while disposing of the representation, comma, certain factors have been taken into consideration, which in the opinion of this court are not relevant to the purpose of such consideration, full stop. The fact that the petitioner had quoted a price which is 5 times higher than the government estimated price has got nothing to do with the claim for remission, which is on account of illegal running of ferries by the concerned Zilla Parishad and Anshalik Panchayat admittedly within a period, within a distance, a radius of 3.2 kilometers from the area of operation of the ferry allotted to the petitioner. Full stop. The order, in fact, states that 4 of such ferries had to be stopped by passing necessary orders, which were indeed found to be operating in violation of Rule 35. Full stop. The observation of this court towards reimbursement of the cost incurred in construction of the foot/bamboo wooden bridge, though was directed to be considered, comma, the same has been linked with the claim for remission, which is not the purpose of such remand, full stop. Para. This court has also taken into consideration the office order dated 22/3/2018 of the Department of the Directorate in the case of Mukalmua Hangonmari ferry service, in which, in more or less similar circumstances, comma, an order of remission was made. Full stop. Though this court has noticed that the order dated 30/10/2017 passed in WPC 6393 of 2017, there was no reference to make any such exercise. There was no direction to make any such exercise, comma, the action of the respondent, exercise, comma, nonetheless, comma, an exercise was done to assess the loss suffered for the illegal plying of ferries in the area of operation by the petitioner. Full stop. In view of the above, comma, though this court is of the opinion that there is no enabling section in the rules of 1968 for payment of remission, comma, since a precedent has been cited in the form of an order dated 22/3/2018 in the case of Mukalmua Bhangonmari ferry service, and also the aspect that the relevant factors have not been taken into consideration in the order dated 9/8/2023, which is the subject matter of challenge in the second writ petition, comma, the issue is remanded back to the Director, Inland Water Transport, to take a fresh decision. Full stop. This court has already noticed, as indicated above, that in the representation filed dated 24/7/2023, comma, reference to the office order dated 22/3/2018 of pertaining to Mukalmua Bhangonmari ferry service has already been taken, comma, while considering the present case, comma, the earlier order may also be taken into consideration. Full stop. Let the aforesaid exercise be completed and the consequential order be passed within a period of
3 months.
not 3 months. You are still running.
It is temporarily I am allowed to run my case.
Within a period of. Is there any embargo for elections?
Yes, Lord, model code of conduct.
Model code of conduct can't even pass an order over.
Order will pass, but you will verify the other.
Within a period of 60 days from today. From the date of receipt of a certified copy of this order.
Hello, may I point out one thing, my lord? The earlier order that was considered on 22 March 2018, there was a specific pilot 35 was pilot complied. That was specifically mentioned in the last parameter. Rule 35. Complying that provision.
They will consider, my lord.
But that may be
Lord,
reflected, my lord.
I have a simple prayer, my lord.
That is there already.
Lordship, I have a prayer, my lordship, may kindly specify regarding the bamboo bridge. Because since there is no permission, prior permission for construction of this bridge, then may be separated. Segregated from the remission.
We are not on the count of remission. Nothing
It is
else.
considered for another.
Lordship, may kindly specify, otherwise, honorable court order.
The present direction.
Already, whatever my lord, I am claiming, my lord, as per the 34, here is a specific provision is, my lord, ferry service is more than 14 days is stopped. So I may be allowed for the remission as a specific provision. Under that provision, my lord, I applied, my lord. Because subsequently I was compelled to construct the bamboo bridge. Otherwise, nothing to be remains.
Lordship, may kindly specify the bamboo bridge part, my lord.
The consideration as directed above would be done strictly in accordance with the rules.
My lord.
এখন হেৰি এখন এখনৰ এটা কপি এটা ৰাখি থৈ দি পাইছা ন Madam, you can take back this copy.
My lord, the earlier High Court order, my lord, I have annexed in my reply, my lord. So lordship will kindly peruse page 46, paragraph 4. My lord, that direction, my lord.
Jirat.
Yes.
Yes,
They were
what is your take?
For Jirat lordship, we have stated in our affidavit lordship. Paragraph 5 lordship.
Affidavit.
Lordship.
By Devanand Dolagapu.
Yes, lordship.
Paragraph 5.
Yes, lordship. May I read lordship?
Please.
That the deponent takes to state that the petitioner has received compensation of rupees 20 only
for the damages of Jirat and standing properties affected due to the improvement of Haflong Tinali to Lower Haflong Road under Assam Mala project at Dehangi Tinali area, and the prayer of the petitioner for enhancement of the amount as additional compensation over and above the compensation of rupees 20 cannot be entertained, as
Okay.
all the government development project affected people were paid compensation on the basis of equitable, reasonable, and uniform schedule rate of Jirat and civil structures fixed by North Qatar Hills Autonomous Council, Haflong, and APWD respectively.
Well, kindly come to paragraph 6 of their regarding epic.
They have said it is payment for Jirat.
That is the case, my lord. Till now, they have suppressed this fact. Kindly come to their affidavit, paragraph 6, my contradictory statement. That the deponent begged to state that the petitioner plot of land is located at Dehangi Tenwali in between so and the land measuring, my lord, kindly see, 3 lessers only is affected of the petitioner, excluding 10.5 meter of existing reserved PWD road. And in the said affected land, only 1 number of memorial stone and some portion of retaining wall of the compound is affected. Next paragraph, my lord. The deponent begged to state that in this particular process, no structure or dwelling house or any valuable trees or deer were found to be affected in the state affected land of this and stated by petition. Now, my lord, your lordship, my lord, this has to be done strictly under the Right to Fair Compensation Act. Now, my lord, your lordship is surprised to see when the court has passed an interim, my lord, direction in 18/1/23, they were specifically directed, my lord, to make a assessment of the Jirat value and submit a report, my lord. Till now, my lord, we have filed our reply, my lord. Neither they have honored the court order, neither they have stated anything in their reply, in their opposition, my lord. And that is, my lord, very arbitrary, they are doing it, my lord. At least,
One second. Where is the order of the court?
early, my lord, I have annexed in my reply, my lord, page
No, the court's order, which 18-1?
18/1/23, my
Yes,
lord.
in the interregnum.
Yes, in the interregnum.
Take photographs.
Not only photograph, my lord, your lordship will or to assess the value thereof before clearing them, because they have acquired that land.
No, was the clearing done after you had approached the court or before?
Before.
If the clearing was done, where is the question of?
No, my lord, their stand was there, the land was that stone memorial, my lord. Your lordship will refer to the, before that paragraph, referring to the stone memorial in the order indicated in the photograph at page 37, it is submitted by Learned Standing Council for that the state memorial has taken over by the Archaeological Survey of India.
Yes.
Long back, which is not included in the land acquired by NC. That is their stand, my lord. And now contradictory stand they have stated in paragraph 6, my lord. In their paragraph 6 affidavit.
What has been stated? Where is that photograph in the writ petition?
Page 37.
37.
Page 37. My. This is a stone memorial, my lord, belonging to my lord 62 area, and this is included in the land of the petitioner, part of the petitioner land. But page 37, my lord, that is a stone memorial, and below there is a retaining wall. And we have stated in paragraph 5 our read petition, my lord, what are the Jirats, my lord. But till now, my lord, neither they have made any assessment nor sought any followed any provision of the right to fair compensation. That is my prayer is also that, because they have nothing to show, my lord, that they have assessed or followed the provision. In paragraph 6, my lord, if your lordship see here, it's a very contradictory, my lord. They admit that they have acquired that memorial stone, my lord.
Where?
Paragraph 6 of their affidavit of respondent 4.
Paragraph 6.
Yes.
Where is the admission that they have
One
Required by-
number of, my lord, that line, my lord, in the said affected land, only one number of memorial stone and
Yes.
some portion of retaining wall of compound is affected.
Where? Paragraph 6.
Paragraph 6.
Yes.
That the deponent beg to state that the petitioner's plot of land is located at Dihangi Tiniali in between chain so and so. In the land measuring 3 lessers only is affected of the petitioner, excluding 10.5 meter existing reserve PWD road. And in the said affected land, only one number of memorial stones. That stone, my lord. And some portion of retaining wall of the compound is affected. My lord, kindly see the order of Honorable High Court on 18-1. Contradictory stand was made by them, saying that the land was acquired by archaeology. So my submission is, my lord, they have not followed the act of 2013, my lord. Till now, they have not annexed any document. This respondent for, my lord, he has not taken any duty to respond to the court order, my lord. And in my reply, I have annexed the.
Yes, Mr. Das.
Lordship,
In the
regarding
court,
the-
you have said on 18/1/2023 that the memorial has been taken over by archaeological
Yes.
survey and it is
Yes.
not included in this land acquired by your council.
Lord,
Now, in the affidavit, you say that one stone memorial.
Lordship, that is the wrong submission which I was made at that moment of time, Lordship, as I have been informed. But actually, the memorial stone, which is located in the Demarcation district, is in Maibang, not in Dihangi Tiniali. This is the memorial which I have been informed that this memorial has been built by the petitioner himself in the memory of some of their relatives. That has been affected. The prayer of the petitioner in the writ petition is that he wants the enhancement of the land.
No,
compensation.
not that. My
That
is
is there, Lord.
strictly for Dirat, my lord. Yes, paragraph, prayer is at paragraph 16, my lord. Dirat and to follow the provision of right to fair content.
To make an assessment and verification of the petitioner's acquired portion of land and standing properties affected by
Page
the
16.
Page
16.
Please read.
Lordship, as to may I read?
Yes, please.
As to why the respondent authority shall not be directed to make an assessment and verification of the petitioner's acquired portion of land and standing properties affected by the Assam Mala Road project, while undertaking improvement and upgradation of road from Haflong Tinali to Tehangi and thereafter to fix the Dirat compensation of the petitioner acquired. First, he wants the assessment of the land, thereafter Dirat.
Because Dirat has not been paid till now. And the provision of the excise, my lord, they have to.
And this amount of 5 lakhs odd, what is this?
That is, my lord, I have
already
stated, that is land compensation, my lord.
Where have you stated?
Paragraph 2, my lord. And they directly, my lord.
Paragraph 2 of your reply.
Paragraph 4, my lord.
Of your reply.
Of my read petition.
Read petition.
Yes. Page 6, paragraph 4. Very surprising, my lord. This. May I read it, my lord?
Yes, where is your assessment?
Nothing is there.
Let us see your assessment.
Right now, I don't.
You get the assessment. Everything will be clear.
I will.
Under what heads you had paid 5 lakh something?
Yes.
Because you are stating that 5 lakh 17 is on the account of Jirat. That means if you have already paid for Jirat, you have to pay for the land.
Yes, that is what.
No, as received compensation of rupees demand only for the damages of Jirat and standing property. Yes.
Have you acquired any land or not?
But the land has already been acquired.
If you've acquired it, you have to pay a compensation for land also.
Yes.
How much is the land compensation?
But if that I have to.
You take instructions.
Their affidavit is totally silent, my lord.
Okay.
They have concealed of it.
Heard. Sri B. Barwa Learned Counsel for the petitioner. Full stop. Yeah, also heard. Sri R. M. Das. Learned Standing Counsel. NCLs. NCHAC. Full stop. Do in the counter affidavit filed by the respondent number 4 on 29/5/2023, it has been stated that on account of Jirat for standing properties, an amount of rupees 5,17,155 has been paid, according to the version of the petitioner, as stated in paragraph 4 of the writ petition, such amount is only on account of acquisition of the land and does not pertain to any Jirat compensation. Full stop para. Let specific instructions be taken in this regard, and the relevant records be produced before this court on the next date. Full stop para. As agreed to by the parties, list on, we'll have it on 24th of April.
Can it be later, Lord?
26th?
26.
F1 and Bodler. Also had and Bodler, then Standing Council Revenue Department and 3J Hendik, State Council. Okay.
May I please, your Lordship?
Yes.
Lordship, as per the last order dated 29/02/2024, this matter has been sent to the mediation center for mediation, and as both the parties have agreed to amicable settlement, the mediation took place on 20th of March 2024, and then they have given their report subsequently on the next date.
Is it settled?
No, Lordship. No,
Not settled.
Not settled. So the Lordship, the mediation center has reported that they require.
Willingness to amicably settle. No, do you need further sitting?
Yes, Lord.
Okay. We'll have it after a month. When is the next date fixed?
Not fixed, Lordship.
Not fixed. Okay. In this matter, an order was passed on 29/2/2024, referring the same for mediation under the aegis of the Guwahati High Court Mediation Center. It was held here? Okay. It appears from a report, from a note dated 22/3/2024 of the Registrar General, Secretary in charge, Guwahati High Court Mediation Center, that the first sitting was held on 23/2024, wherein the parties had appeared and expressed their willingness to have an amicable settlement. Full stop para. In view of such positive development, let this matter be again taken up by the learned mediator. Is any next date fixed?
No, Lord.
Fixed. As per convenience of the parties. Full stop. The learned counsel appearing for the parties are required to serve a copy of this order, copy of today's order, to the learned mediator to facilitate him to fix a date for the next sitting. Full stop para. Let the matter be listed before this court after on 17th of May 2024, on which date, the progress made, in the mediation, if including any final order of settlement, may be intimated to this court.
Hearing on behalf of President number 1.
We have not recorded anybody's name.
Deeply applied.
Who is the mediator? Who is the mediator? No idea.
No lordship.
How will you serve then? Whom will you serve? Mediator is Sri Imrul Hassan. Hi Hassan, you know him? Hi Hassan. Okay.
Deeply applied.
The learned mediation center of this court to facilitate holding of the mediation as directed by this court.
May I please, Your Lord? In this case, my learned friend has submitted this activity minute. We will be given a short time, and by 24, you will have to fix it. We'll give a reply.
When did you file affidavit, Mr. Sharma?
On 16th, Your Lordship, but it's not in the record.
Okay. Part 3, SC Business Learned Counsel for the petitioners. Para. Sri H. Sharma, Learned Additional Senior Advocate Assam, however, submits that on 16/3/2024, the affidavit in opposition has been filed, which, however, has not been tagged with the records. Full stop. Para. Sri Vishas, the learned counsel for the petitioners, has also submitted that he would like to file a rejoinder affidavit. Full stop. Para. Let such rejoinder affidavit be filed and the matter be listed
24.
for consideration on
24, my right.
24th of which month?
Of this month.
This month?
Yes.
On 29th.
Of right.
29/4. Full stop. Affidavits filed may be tagged tagged with the records.
But item 35 is your same.
Same.
Same, but they have not filed any affidavit in 35.
This affidavit will cover the item 35.
Yes, yes.
List along with that. List along with WPC 5452024. And in 35, right? Part so and so and so and so. Huh? It is submitted by Sri H. Sharma, learned additional senior advocate, that there is an analogous matter being WPC 4303/2023, in which affidavit in opposition has been filed by the respondents. Full stop. Para. Not para. It is submitted that the said affidavit would also cover the present case. Full stop. Para. Accordingly, list along with WPC 4303/2023 on 29/4/2024.
Item 31.
May I please, Your Lord? This is a land acquisition matter. Notice was issued, but instruction was also sought for. But possible. Land has been acquired, my lord.
When?
My lord, and thereafter, my lord, we file a writ petition for compensation, and your lordship passed an order that is page 65. There is direction that within 6 months they will complete the process, but that has not been done. What happened?
Lordship, in this case, Lordship, we have received one instruction on 30th of October 2023. At that time, we have received an instruction that the Deputy Commissioner has informed the NHIDCL as well as the PWD authority to give us the money, as because we are only disbursing authority. And thereafter, Lordship, there is no such communication. So, Lordship, may I get
the requiring authority is whom? PWD.
PWD as well as NHIDCL.
Yes, who's NHIDCL and PWD, Mr. Chaudhary? Yes, for PWD. Yes, have you paid any money to the government for payment? To the deputy, you are for the deputy commissioner.
Lordship.
Instructions. And NHIDCL. RK Talukdar.
NHIDCL.
T. Barua.
IA to stop the But in NHIDCL is not a party in the writ petition. Thereafter, they have told me that then IA was filed, where is filed or not, like I know. Then NHIDCL, they have to make a party law.
There is direction page 65, that is to the NS division, my lord. PWD NS.
No, that is a different incumbent altogether. If Mr. Sharma on instruction is submitting that it is both for PWD, NH and as well as NHIDCL, I think it's better to have NHIDCL on board. At least we can get the instruction whether they have paid to the DC for onward payment. You file an IA.
তোমালোকৰ কাৰণে ভাল হ'ব, নহ'লে আকৌ committee. In the meantime, let me get this.
I think they also have a standing council, Mr. Ho.
NHIDCL, yes, Lordship. For National Highways, Chandra Boro appears, and he told me that some.
RK Boro is there, I think. Then RK Talukdar is also there.
Yes, RK Talukdar. But he is not a party here.
Mr. Boro, R Boro is also there. R Boro, I think it is Mr. C Boro. Heart 3 and Hoc Learned Council for the petitioners who have submitted that the subject matter involves a claim for acquisition compensation. Full stop para. Sri H. Sharma, learned additional senior advocate Assam, however, submits that the acquisition is made both for the PWD within bracket NH and the NHIDCL, and whereas PWD NH has been made a party respondent, comma, NHIDCL has not been made a party respondent. In fact, Sri B. Chaudhary, Learned Standing Council, is present for PWD NH and has prayed for some time to obtain instructions as to whether there has been any release of funds by the department to the office of the Deputy Commissioner, which district? Gwalpara, for onward release to the affected person. Full stop para. Considering the above, comma, list this case after 3 weeks to enable Sri Chaudhary, the Learned Standing Council, to take further instructions. Full stop para. Sri Hoc, the Learned Council for the petitioner, has also submitted that in the meantime, comma, he may be given liberty to file IA for implement of NHIDCL. Full stop, liberty granted. List after 3 weeks. We'll take some bail matters are there, 3 bail. Are the petitioners there, Madam Begum? Bail. Bisidas, J. Sakya. R. Dhor. Rupok Dhor, yes.
38. Earlier rejected on 19/10/2023. FIR lordship will find at page 60.
You've got the up-to-date case diary.
Lordship, up to date, all the witnesses are the statement of lordship. They have implicated him, lordship.
Lordship, the informant is Sri Jyotish Chandra Haloi, FCS Baksa. He is the inspector. The informant lordship will find at page 60, the Jyotish Chandra Haloi, who was the inspector of food and civil supply. Now I have filed an additional affidavit to bring on record that I have been made prosecution witness by the government lordship in the departmental case. Lordship will find at page 70 of my additional affidavit. And type copy at page 68.
Was it rejected earlier?
Earlier rejected,
Where is the rejection order?
Page 62, Lordship.
page 62.
62.
Lordship.
Yes.
Page 63 is the operative.
Yes.
Now, Lordship, if your Lordship comes to page 60, this is the FIR.
Page?
Page 60.
Now, where is the document?
Lordship,
That,
now I have filed an additional affidavit to bring on record
yes.
that I have been made prosecution with
Yes,
them
which page?
at page 68.
68. So where is your apprehension that you'll be arrested?
No, now this is the latest development. That is why I filed in the additional affidavit. to
So
bring
where is
on
the
record.
apprehension?
Now there is no apprehension otherwise.
Oh, okay, you withdraw
Since
this.
I have been made prosecution witness.
Withdraw this.
And this Jurisdictional Halloween is the main person who is involved in all these cases, Lordship. And I have been made scapegoat. And nothing else, Lordship, by these people. So Lordship may grant bail, Lordship.
Now, why should I grant bail?
Because I have been, although I have been made prosecution witness, but there is a.
Where is the apprehension? If you are a prosecution witness, you have to show an apprehension, they will be arrested.
Yeah, Lordship. Lordship is very correct.
Yeah, AB is an exception that you are apprehending arrest. If you have made out a case, what is your name?
My name is Deepak Boro.
Okay.
That is serial number 3.
You have shifted.
Lordship, I've been made prosecution because I have done nothing, Lordship. No recovery, nothing. Only this person goes, the informant in connivance with others, made me scapegoat.
This is the prime time for shifting.
And I have also appeared before the police, Lordship.
Shifting is going on.
Oh, before the authorities. Shifting, Lordship.
Shifting is going on. So,
yes.
third, Sri Ardhar, learned counsel for the petitioner, who has filed this petition under section 438 of the CRPC in connection with so and so, full stop. Also heard Miss A. Begum, learned additional PP, who has produced the case diary, full stop. Para, without going into the merits and grounds, the merits of the allegation, deep, comma, Sri Dhar, the learned counsel for the petitioner, by referring to the additional affidavit filed in this proceeding on 6/4/2024, has submitted that the petitioner has been asked to appear as a prosecution witness, full stop. In this connection, comma, reference has been drawn to a communication dated 16/3/2024, issued to, amongst others, comma, the petitioner. It's not prosecution witness, it's a DP.
Yes, he is a prosecution witness.
How?
Lordship, if your Lordship comes to page 70, in inviting reference to the above, I am to inform the that
70?
you have been, yes, Lordship, cited as prosecution witness.
Where?
Page 70, verse 2 line, Lordship. In inviting reference, Lordship got it.
In what?
In additional
Prosecution witness in what?
in this Department of Proceeding.
In the DP?
Yes.
You will be arrested in the DP?
No.
Then?
In a police case, Lordship, I will
Police
be
case is a
arrested.
different context.
But the person who has filed the FIR, he has been held to be guilty of all these things, Lord.
Mr. Dhar, don't confuse yourself and don't make this submission. It will not be good for you and your client. You are called as a witness in a DP.
Yes, Lord.
This may indicate that you may be a prosecution witness in the criminal case.
No.
But this is not a document to show that you are a prosecution witness.
Not in the criminal
Neither
case,
a
in the
reprover.
DP.
Will you be arrested in a DP? Have you heard somebody arrested in a DP?
No.
Then where is your apprehension? You are apprehending arrest in a police case.
Yes, Lord.
And you are called as a witness in a DP.
DP.
Then
The person who has been this letter which has been issued on
see, when an accomplice evidence can be taken into consideration,
Lordship.
there is no bar, only corroboration is required.
Yes.
You can be an accomplice. Will it absolve you from the criminal liability? Not at all.
Not at all. But what I
Your
submit is
apprehension is
that,
still there. You gave a different idea, or maybe you have not understood the concept.
no, what I
You have said prosecution witness here. Where?
in a department.
In a department of proceeding.
Yes, not in the criminal case. But thing is, the person who is involved in the corruption charges, Lordship, he has been asked to appear in the DP, Lordship, and I have been made prosecution in the DP. Therefore, Lordship, my responsible submission is that there is nothing in the police case, Lordship. I have also given my statement. I will appear before the police, and whatever
Where did you
required
give your statement?
in the departmental proceeding.
No, not in the police. 161.
Not in the police, sir.
Have you appeared?
No. In the DP, I have appeared on the day, and I take it also.
If you have appeared
Now,
for the
now
DP,
if
then
you
there is
Lordship
no apprehension.
consider my case, and I will appear as whatever Lordship may
We
pass.
thought we accepted your projection. You are making a wrong projection. We will not say you have any intention, but your understanding is not correct. It's in the context of a DP.
Yes, DP.
Cool. Yes, what do you say, madam?
There is allegation, Lordship, they have all the
Allegations are there.
allegations are there.
Where? What is your name, Mr. Dhar?
Lordship.
What is your name? Deepak
Deepak
Bodo.
Bodo.
Lordship.
I'm only the secretary, not the
But we have
president,
not been
not the
distributed.
chairman.
As the secretary has not provided the rice.
Lord.
There are 15 members, employees, Lordship, those who are elected representatives. Only I am the secretary. And the rice which have been said to be stolen or whatever it may be, Lordship, these are not recovered till date, Lordship. There is no recovery at all.
Where will be that recovery? You have already sold. It is in somebody's stomach and already gone somewhere else.
Such a huge quantity within a period of
Huge quantity, only one man will consume.
like whatever the allegation in the
You have
FIR
sold in the open market. Thousands have brought it.
that those can be
Gone.
recovered by the police, Lordship, if efforts are made, Lord.
Recovered from where?
As per the allegation that it is
Is it in the,
sold in the open
is
market.
it still in the form of rice?
That I can make any comment, Lord, which is to be
Very difficult to recover. Impossible.
and Lord,
Digested.
it can be also be presumed that I have not sold. Someone else is behind. Lordship, what I submit is that Lordship, I will appear whatever condition, Lordship. I will appear before the police. If your Lordship passes order within 3 days, I will appear.
If that submission cannot be accepted because even in the heinous of crime, everyone will say I'll appear. If we grant bail, anticipated bail, will somebody say I'll not appear?
No, I will appear.
That is not a consideration at all. You appeared without an order. Try your luck. There are allegations against you.
But since departmental proceedings, whatever allegations is there is against that informant law in department. Considering that next,
I think this you should have moved on Wednesday.
Wednesday.
Should have, ideally.
Then Lordship,
Consideration could have been slightly different.
Lordship, let it be on Wednesday, Lordship.
2 days are still there
Lordship,
against you.
let it be on Wednesday, Lordship.
Likha, yes. Full stop. By the said order, comma, the, on a careful perusal of the said order, comma, it however reflects that the petitioner has been asked to appear as a witness only in the departmental proceeding, which may not lead to an inevitable conclusion that he has been held to be an approver in the criminal case. Full stop. Para. In the case diary submitted by Ms. Begum, the learned APP, comma, this court has found that there are certain materials, including allegations that the petitioner had not provided the rice. Full stop. Para. Considering the entire facts and circumstances, and also the aspect that the petitioner has been asked to appear as a witness in the departmental proceeding, comma, it is directed that the requirement of custodial detention of the petitioner may not be there. Full stop. Para. Accordingly, the instant application is allowed by directing that in the event of arrest, comma, the petitioner would be released on bail on submission, on furnishing a bail bond of rupees 20,000 with a COT of like amount, subject to the satisfaction of the arresting authorities. Full stop. The petitioner is accordingly directed to appear before the IU on or before 19th of April 2024 for recording his statement and for corporate.
My objection may be recorded.
You have said there are allegations. Ms. Begum, while objecting to the application for bail, has also produced the case diary. That's a perusal, no? Case diary returned.
Lordship, in this case, we have not received the CD, Lordship, and no one is.
None appears for the petitioner on call, whereas Ms. A. Begum, learned additional PP, is present. The petitioner has remained absent continuously on the last 3 occasions, namely 5/3/2024, 15/3/2024, and 2/4/2024. Full stop. In fact, in the last order dated 2/4/2024, comma, an observation was made that in case of further non-appearance, comma, this court would proceed with the matter and pass appropriate orders. Full stop. Para. This court has noticed that on 2 previous occasions, comma, the prayer for anticipatory bail of the petitioner was rejected, and further that no new grounds have been made out. Full stop. Full stop. In view of the above, comma, this court is of the opinion that there is no requirement for reconsideration, and accordingly, the bail petition stands rejected. $37. None appears for the petitioner on call, whereas Miss A. Begum, learned APP, is present with case diary. Full stop. Para. This court has noticed that even on the last occasion, i.e. 5/2/2024, comma, there was no representation on behalf of the petitioner. Full stop. Para. In the interest of justice, a final opportunity is granted by adjourning the matter and directing the same to be listed on 22/4/2024. Full stop. It is, however, made clear
City to be
that
returned.
in
City to be returned, Lord.
it is, however, retain the CD. Or we'll have it early then. Early will not, may not be possible. It is, however, made clear that in case of further. Is it the first time it's coming?
No, Lord, there is city is also
okay,
not up to date, Lord.
In case of further non-representation, comma, this court will pass appropriate orders. It's up to you how to, but next date, keep the CD handy. If you want to return, bring it back. Next date, we'll pass final orders. Yes, next.
Item 42. May please.
32 would be the last case, perhaps. Yes.
Inspector,
Well, now affidavit is ready, man.
What is the matter, Mr. Chauhan?
well, some article has been seized by the police, my lord, respondent, which
Under
without any, showing any, my lord, cause.
articles like
Like, my lord, the some dismantle portion of mobile tower.
mobile tower.
Yes, Reliance.
Who are you?
My lord, I am the landowner. My lord,
Over which the mobile tower was
yes,
constructed.
yes.
It has been recovered from your possession.
Yes,
Seized.
it was, yes, my lord.
Yes, what is you do?
One FIR was there, my God. He'll be filing a affidavit within a short period.
Oh, there was an FIR
Yes.
against him.
Look, I'm not informed. Okay.
You are not aware of any police case?
No, man.
Who is respondent number 4?
My lord,
Informant.
in charge, my lord.
Police in charge.
Yes.
Part 3. Chauhan, R.S. Chauhan, the counsel for the petitioner. Full stop, para. Mr. Talukdar, for whom? For the state.
For the state.
3.
All the.
BJ Talukdar, senior counsel, appearing for the state respondents. However, submits that there is a police case against the petitioner. And in connection with the said case, comma, the seizure has been made. Full stop. He, however, submits that an affidavit in opposition would be filed, for which he prays for and is granted 4 weeks time.
It's ready, my lord, any day.
4 weeks. List after 4 weeks.
My lord, the date may be. After which, my lord,
List on 13th of May,
published.
Monday. Okay.
May it please, my lord. My lord, if my lord is writing, I have a prayer, my lord. Item 46, today was fixed for interim order, my lord. And the opposition has already filed their affidavit, but the same is not on record. My lord, it's emergency. If your lordship fixes it tomorrow or day after tomorrow.
After vacation, Lord, we have five.
Because my lord, I.
What is the matter?
My lord, actually, I am the chairman of a regulated market committee, and the tenure was for 3 years. And before the expiry of 3 years, they are supposed to conduct the elections and appoint a fresh committee so that the perpetual succession is continued. Since they did not do it, we wrote a representation and they did not consider it. Meanwhile, we approached this honorable court and status quo was directed to be maintained until further orders. Meanwhile, they came and appraised the court that since the 1 year consideration extension period had already expired, therefore the matter is infructuous. So the matter was closed. But however, the extension has not been considered, neither a fresh committee has been elected till date. And recently, the district agricultural officer has been appointed as ad hoc chairman. Therefore, we have approached this court seeking a prayer that until a new committee is appointed, the previously democratically elected committee should be allowed to continue.
What is your term?
My lord, that was for 3 years. However, the
Expired.
rules, yes, it was expired, but we were continuing by the honorable court's order.
No, is there any law by
Yes,
which,
yes, sir. Yes, my
by
lord.
which you can be given extension?
Yes, yes. As per the act, my lord, for every year, an extension can be given until a fresh democratically elected committee is
That extension period is also over.
over, lord. They have not considered my application, my lord. They have stated in the affidavit that was sent for a review of the judicial department, but that was no notification was issued by them granting them
And
an
that period of 1 year is also over in the meantime.
Yes, yes, that was over. However, they have not yet constituted the election committee. They have not notified in a fresh committee, and
Yeah,
we are
but
also not allowed to continue.
Page 52 of the repetition, if lordship pleases to.
My lord, may kindly look at section
You
9.
file affidavit.
Yes, lordship, we have filed day before.
The court
yesterday.
reiterates the observation made in the surrender that if no such affidavit is filed, interim order shall be considered. You have filed the affidavit.
Yes, yes, we have filed.
My lord, we peruse the previous
Total
direction.
Term is
The
over.
previous order, my lord, the honorable court had fixed a very limited question of law, which has
No,
to be
if no
determined.
such affidavit is filed, interim order is straightforward with.
My lord, on the previous order, my lord, 18/3/2024, the honorable court had fixed an important point of law, which was to be determined. They have not addressed it in the affidavit.
Sorry, we could have taken up.
We have addressed it also, section 48.
My lord, my
Sorry.
contention was that
Sorry,
except
sorry.
under particular conditions, it
There is no
cannot. be-
urgency as such. Heard 3A Barwa learned counsel for the petitioner who submits that the prayer for interim order was to be considered. Full stop. Also heard Ms. R. Bora, the Standing Council Agriculture Department, who has submitted that affidavit in opposition has been filed when?
17.
On Saturday.
Saturday.
On 17. 17, so 7.
6/4.
6/4/2024 by serving copy on the petitioner's counsel, which however is not on record. Full stop. Para. The order dated 26/2/2024 had made an observation, contains an observation that the prayer for interim relief is kept open for consideration on the returnable date full stop. Para. On 18/3/2024, which was the returnable date, comma, this court has observed that if no such affidavit is filed, if no affidavit is filed by the department for which 10 days time was granted, comma, interim order as prayed for would be considered on the next date fixed. Full stop. Para. On the next date, i.e. 3/4/2024, comma, the earlier observation dated 18/3/2024 was reiterated and the matter has been listed today. Full stop. Para. The affidavit, comma, of the department, comma, as noted above, has been filed in the meantime, which however is not with the records. Full stop. Though Sri Barua, the learned counsel for the petitioner, has expressed urgency, comma, this court is of the opinion that no case of urgency is made out, as the tenure of the petitioner as chairman is over and also the period of your 1 year, in which the extension can be considered is also over. Full stop. The petitioner assumes jurisdiction to act as the chairman of the market committee.
Yes, my lord.
Only on the
Lanka
basis-
regulated market committee.
Only on the basis of the mandate of the people, which gets over on expiry of the tenure. Full stop. Be that as it may, comma. List this case for consideration after the Bihu holidays
My lord, may kindly fix the date.
on 22nd,
I'm obliged.
22/3, 22/4.
I'm obliged.
Lord, item 33, that is the next item, my lord. May I please for a date, my lord, immediately after
He'll give
24th.
inside of